hearing in the appeal Austin against the Mayor and Burgesses of the London Borough of Southwark.
Mr. Drabble.
Lords, my lady, at the end of yesterday afternoon, I was taking the court to the guidance for social landlords on tolerated trespassers.
Yes.
The purpose of that exercise is to make good my submission that Schedule 11 of the 2008 Act represents a deliberate settlement of a number of difficult issues that arose out of the perceived need to deal with the problems arising from tolerated trespassers. And in the context of this case, its importance is really this, that, as I said yesterday, your lordships and my lady are being invited to depart from the earlier decision of the House of Lords in boroughs, confronted with an invitation to exercise the discretion recognised by the practice direction. A court necessarily has to consider whether it's appropriate to do so itself, because the effects of retrospective change are not so great as to be unacceptable, or whether it should leave it to Parliament to make the change with a number of provisions designed to protect or modify the effect of fully retrospective change. This is really an extreme example of that case. We have on the statute book a highly and carefully developed framework in Schedule 11 for dealing with the changes, all of which would, as I said yesterday, be rendered nugatory if the court was simply to do what Parliament has deliberately decided not to do and make a fully retrospective change.
You took us to part 2 of the schedule, and,
yes.
and we did see, of course, how I think it's paragraph 21 is carefully
yes.
constructed. But I have to confess, I haven't been able to work out in my mind what the effect would be on parties if we were to make the change. The only parties involved, as I understand it, but correct me if I'm wrong, are the social landlords on the one hand, and those who are tolerated trespassers on the other.
Yes.
I mean, I don't think there are any third parties involved here. And is the kind of circumstance we would need to consider a situation which I think is referred to of a tenancy having been granted to tolerated trespassers to put them into some kind of regular situation. So one would have the match between us saying, in fact, they had the benefit of the law as it has been established for assured tenancies, and one's got, as it were, an overlap between two systems. Is that all it comes to, or is there something more to it than that?
It's plain that the government thought there were a large number of issues. I mean, take for example this example. The law as developed in boroughs means that there is no succession if at the moment of death of the tolerated trespasser, as it would be if boroughs is correctly decided. Yeah. If at the moment of death he is a tolerated trespasser, then there is no succession. A very large number of cases will have proceeded on that basis, and the successor would be a successor if your lordships were simply to reverse boroughs, has no doubt disappeared off the scene. There would be an issue as to how to deal with that, as I understand it.
It's people who've gone away, as it were, who might have succeeded.
Mr. Luber is saying that the changes don't deal with that class. That is correct. It may be that it's simply too late, even if your lordship simply reversed boroughs, because the person who has gone away would no longer fulfil the tenant's condition for the secure tenancy. But one can well imagine arguments about what precisely the effect is. There would then be a series of cases in which a new tenancy is granted on a mistaken apprehension of the law, and one would have to deal with that. There's the repairing covenant issue, which is precisely what section 20, say paragraph 21, deals with.
Are these situations any different from that which followed from the House of Lords decision in Knowsley. I mean,
the scale of the problem is completely different. One of the things I was going to take your lordship to, my lady, in a moment, is precisely why Lord Neuberger thought it appropriate to distinguish between approved tenancies and secure tenancies. And a major part of the reasoning was that whereas the position had been clear in relation to secure tenancies, at least since Burroughs, and believed to be settled by Thompson and Elmbridge, so clear for 27 years on that basis, Knowsley itself was the first case in which a court of record had held that the same position applied to assured tenancies. That's a very important part of the reasoning.
Yes. Yes.
And so that, as it were, we have to remember that Lord Neuberger and indeed the other members of the committee would have had in front of them Schedule 11. They did have Schedule 11. There was some discussion about paragraph 21. And Lord Neuberger approaches the matter on the basis that it is acceptable to reverse the Court of Appeal decision in Knowsley because that is a relatively recent development of the law, but not to reverse the approval of Thompson and Elmbridge in Burroughs, precisely because of the scale of the problem that would be created. I'll take you.
Well, I'd like to see exactly what he says.
That in a moment. That's the purpose of the next bit of my submission.
Yes.
Is to make good the proposition that there was a deliberate decision by Parliament not to reverse Burroughs in the sense of a simple retrospective legislation restoring everybody to the status of secure tenants, but instead to produce a mechanism which protected landlords.
When you succeed to tenancy restoration, do you succeed to all the liabilities of the previous tenant? Everything. You just take over where you left off.
If you succeed, the tenancy, according to this, Section 87, I think it is, or 89, Section 89 vests in the successor. The same tenancy vests in the successor. Right. That's the mechanism. Yeah. So, my Lord, can I go back to that guidance and then on to Knowsley and so on, and make good in a hopefully coherent way these submissions? We saw yesterday paragraph 11 of the guidance. And I'll go to that because it makes good my timing point. The second sentence says, most RSL tenants have an assured periodic tenancy. At the time the 2008 Act was going through Parliament, the effect of existing case law was the tolerated trespasser doctrine applied to such tenancies. This was the result of the Court of Appeal judgment in Knowsley, May 2007, which involved an assured periodic tenancy, reversed by the House of Lords, who handed down judgment in early December 2008. The effect of the House of Lords decision is that assured periodic tenancies will not have become tolerated trespassers. And then it goes on to explain that there may be other categories of tenants of RSL landlords who are assured tenancies other than assured periodic tenancies. And the last paragraph says, while it calls a decision to commence in its entirety, whilst recognising that this may render part of the provision in Schedule 11 redundant, we consider it is more prudent to do this than to risk leaving any potential tolerated trespassers unprotected. In the same way, all types of original tenancy have been catered for in the successor landlord orders. I did say yesterday that at commencement, Parliament was aware, or the Secretary of State was aware, that he was making a commencement order which would be indeed nugatory in relation to a large class of assured tenancies, but wasn't quite sure that it was all assured tenancies. That's the approach. But of course, effectively at this moment in time, the Secretary of State has been effectively invited by the House of Lords, if I can put it this way, in Knowsley, to make that distinction, because the House of Lords had drawn back in Knowsley from saying Burroughs is wrongly decided. It's true, they'd drawn back because no one invited him.
Nobody asked. In fact, if anything, positive discouragement as far as...
Well, I rely on that. I mean, it's not a cheap point. It is that there was a genuine recognition. There was some debate amongst council before Knowsley was argued.
So it's an informed discouragement.
I'd have loved to have been in the corridor outside.
Well, it was a bit before that. And a genuine recognition that there were problems that would have to be addressed if you simply reversed Burroughs and went back to square one, because an awful lot of things have happened since Burroughs.
But does it not follow that as a result of the agreement between Council and the manner in which it was put to the House of Lords, that the House of Lords in fact refrained from embarking even on the question whether it would be appropriate to re-examine these authorities? There certainly was no argument advanced to their lordships to the effect that it was appropriate to re-examine the authorities. The opposite has just been pointed out to me. But it is crystal clear from the speech of Lord Newburgh that he himself thought it right to consider for himself whether he should suggest the reversal of Burroughs. Now, is that right? He did it in a reasonably guarded way, did he not? He said that he suspected that if they had turned their minds to it, and that's a very crude paraphrase, that they might have reached the same view in relation to secure tenancy. But the impression that I got, and it may be that this is wrong, is that the argument didn't get past first base. There are various stages. First of all, because of the agreement of Council, the court decides not even to go into that territory. Second stage may be, well, it looks at goes into the territory, but decides, well, no, because of the well-established rule, we're not going to review it, and we'll give an oblique comment that we might have taken a different view had it been open to us. Now, I wonder whether it had got to that second stage with Lord Newburgh, or whether he and his colleagues refrained even from going into the second stage, so to speak.
My submission is he plainly went to the second stage. Admittedly, I was going to go to it in a moment,
yes.
and I will do.
I'm sorry to interrupt.
No, it's important. He admittedly went to the second stage only of his own volition. He wasn't invited to go there by Mr. Luber as part of his argument on assured tenancies, and possibly more relevantly by me, because I was arguing to defend the position of two secured tenancies in relation to other issues that have arisen from the status of tolerated trespassers. Judgment that I formed, I make no bones about it, was that I would win anyway. It turned out to be correct, and so in a position where Parliament was addressing it, and where one would have had to have the argument I'm now having against myself about whether it was right to reverse Burroughs in the face of Schedule 11, that choice was made. But then Lord Newburgh was plainly sceptical about Burroughs, and one census was sceptical about Burroughs at the time of Burroughs. Looked at it for himself and decided not to. In our submission, for three fundamental reasons. One was the agreement of Council and the absence of any submissions as to consequences, which I'm now making. But two was the large number of transactions which had taken place on the basis that this line of authority was correctly decided. And three, that the issue was being addressed only prospectively by Parliament in the legislation that was in front of it. I'll go to the passage in a moment. But
That's normally the way Parliament proceeds anyway, isn't it? I mean, retrospective legislation is not something Parliament would usually engage in. I know there are some passages, some parts in the schedule that do actually are without limitation in terms of date, but there are very specific points which are apt to that kind of treatment.
But Parliament had the option, which it consulted on as its desired option. Sorry, the government had the option, which it consulted on as its desired option of a full retrospective reversal of boroughs. It can do that.
Absolutely right.
And I was going to show the court in a moment. Representations were made once the government had made plain that its position was simply reverse boroughs. Mm-hmm. The local authorities in particular made a series of submissions, but don't do that because we've been conducting our affairs in perfectly good faith for years on the basis that boroughs is good law, and we don't want to be met with a whole series of actions which are premised on the basis that transactions arise out of a mistake of law. And so the history goes, consultation on full retrospective reversal, representations that that's not a good idea. Government thinks about whether it can simply safeguard the position of landlords in relation to some of the transactions, but instead, this is what comes out of the later passages of the guidance, opts for a situation which is Schedule 11, which is that, generally speaking, it's not retrospective, but it is retrospective for certain purposes, succession being one of them, and can be made retrospective by the exercise of a discretion of the court in an individual case in relation to, say, repairing covenants. That's the machinery.
Have we been shown anything that discusses the succession problem? I'm sorry, failure of recollection. But
there's something in the guidance I'm about to go to.
Oh, thank you.
But it doesn't deal with, I accept, it doesn't deal with this case. I mean, i.e. the situation where there isn't a succession because of the the absence of a full retrospective reversal of boroughs. That isn't discussed as far as I can see.
And that is interesting, is it not? Because one of the points you've just made is that a very large number of people would have succeeded if the tenancy was still in existence, because we're talking about thousands and thousands of tolerated trespassers, and no doubt many of them will have died in the intervening period. So you're saying that that's a large group of people who potentially were affected, and yet it doesn't seem to have been thought about in the...
Well, I put it the other way around. Because of the range of problems that full retrospectivity would give rise to, a solution which was adopted and deliberately adopted, which dealt with the position of people who in the future will be able to take advantage of the right to succeed, but didn't reverse the position for those where the death had already taken place.
Yeah, I understand that, but I'm really getting at whether there's any discussion of that, because all the emphasis in the discussion, frankly, is on repairing covenants, and one completely understands why, because that's a nightmare scenario for especially London. Local authorities over the past few decades. But so anyway, you're going to take us there.
Well, I'll go there and I'll have further comment in a moment on that. So that's the timing point in paragraphs 11 and 12 of this guidance. I took the court yesterday to paragraphs 58 and 59. And paragraph 58, as we saw yesterday, says Part 2 restores tenancy status by creating a new tenancy which comes into effect on commencement. An alternative approach would have been to revive the original tenancy, i.e. to treat it as though it had never ended. Indeed, this is the approach on which the government originally consulted. However, it was recognised that if tenancy rights were to be restored retrospectively in this way, sufficient safeguards would need to be put in place to ensure that landlords were protected from claims arising out of decisions made in good faith on the basis that of the occupiers were tolerated trespassers. Such an approach was likely to be both cumbersome and risky.
What kind of claims are envisaged there?
I think I can't go further than the ones that we have already been discussing, but I caution against putting any trust in my own ability to identify them all. We'll see in the summary of the consultation responses that this point that's made in 58 is recorded as having been recognised by almost all the respondents. I don't mean local authorities, all the people who responded to the consultation, that you would need to have in place safeguards to deal with the possibility of claims arising out of the fact that transactions had taken place on a mistaken basis in law. I don't hesitate to try to identify them all myself, but...
Give us a paradigm.
Well, the paradigm is repairing governance.
Is what?
The paradigm is repairing governance.
Yeah.
And are they, I mean, I'm not quite sure I've fully grasped that one even, what the difference is between the situation as it is, as it were, and what would happen if boroughs was reversed.
Well, the facts of this case may be an example. On the law as it stood, stands if boroughs is rightly decided, the court confronted with an application to revive the tenancy, the Lazarus order, by postponing the date of possession until after the date of the court order, and therefore tenancy comes back into being. The court has a discretion whether or not to make that order, and I'm going to take your lordships in a moment to a case of Lambeth and Rogers, where the Court of Appeal discusses the basis on which that discretion is to be exercised. And it's plain that it would probably not be exercised in favour of the tolerated trespasser if, at the moment of the application for the order, there were, say, very substantial amounts of rent arrears.
But if the order is granted, and so Lazarus arises, then the repairing covenants also arise retrospectively. And therefore the landlord is in breach.
If the premises are in a state of disrepair, there may be a very substantial damages claim, or small or very substantial damages claim.
Would the court be entitled in its discretion to say, okay, that repairing covenant, so to speak, is operative, but you can't, so to speak, claim for all these years, months, or whatever it is, that you were in arrears and a tolerated trespasser?
Well, your lordship said the answer to that question was yes.
I think I did, didn't I? I thought I said that, yes.
But I don't think there was some debate about that in Knowsley, as your lordship may or may not recall. But it's not necessarily for my purposes to give an answer to that. What matters is that confronted with a situation where there was a discretion to deal with the tolerated trespasser in the repairing covenant, Parliament chose deliberately not to simply sidestep that discretion by a full retrospective amendment, by a full retrospective restoration of the tenancy, but chose instead to replicate the Lambeth and Rogers solution.
If one contemplates the repairing covenant point, while the person in possession, as it were, if the property is simply a tolerated trespasser, then there isn't a covenant. And one can imagine that authorities pressed with the resources and all the rest of it would say, well, we'll concentrate on the cases where there is a covenant and we'll direct our resources there because we actually have to do it under contract, but we won't do it for the time being, at least in cases of tolerated trespassers, and therefore, the need for repair grows because things are left in a state of disrepair for longer. Is that the kind of thing that one should have in mind?
That's certainly a possibility. Like Mr. Loomer, I suspect that in practice, very many local authorities don't actually distinguish between tolerated trespassers and others.
And we saw yesterday that there is liability for nuisance, even in the case of a tolerated trespasser.
And they have an interest in keeping up the standards of their housing stock because they may actually find they using the property for somebody
Yes.
else next year or something like that.
Yes.
And a large quantity of these dwellings in this part of the world, at least, are flats or maisonettes, where you've got to keep up the building, you've got to keep up the common parts in
Yes.
any event.
All of this is correct. It's also correct that there are very large numbers of properties that are simply in disrepair anyway. My submission doesn't need to go any further than that Parliament recognised there was a policy decision to be made as to whether or not to simply retrospectively revise the tenancy with all the incidents that follows from that, the restoration in full of, it's not just repairing covenants, it's all the covenants of the tenancy and all the other attributes that go with the status of a tenant, or to devise a machinery such as paragraph 21. I think my case comes down to the fact that in a situation where the practice direction is in play, that is, you're being invited to depart from a previous decision of the House of Lords, which is the reality of this case, it is inappropriate and actually positively contrary to the orderly development of the law to render nugatory a very carefully considered settlement of a problem which obviously exists. Even if there wasn't the 2008 statute, your lordships and my lady would have to think about whether it was right to upset an existing line of authority with retrospective effect. If I was representing Southwark, I'd plainly be saying, no, it wasn't anyway, quite independently of the 2008 Act. But once you've got the 2008 Act, then in my submission it's simply not acceptable for the court to circumvent the machinery.
Well, thank you very much. Is there anything more in the guidance?
That's 58 and 59.
Yes.
And your lordship, my lady, will see the 58 has said, 59 said, it said it was decided to create a new tenancy, provided that for certain relevant purposes the original tenancy and the new tenancy is to be treated as the same and continuous. In this way, the provisions ensure that as far as possible, neither landlord nor tenant are disadvantaged by the tolerated trespasser period. And then the relevant purposes are, A, to ensure that the tenant who has already become a successor under the original tenancy does not acquire additional succession rights. There can only be one succession by law. And then there are various other purposes which are set out, which I need to go to. And then your lordship and my lady will see over the page that under the heading relevant claims, the guidance describes paragraph 21(3) and in paragraph 64 says when considering such a claim, it will be for the court to decide whether to take into account the tolerated trespasser period or not. Courts have already been making decisions of this nature when dealing with claims concerning tolerated trespassers. While a tolerated trespasser has no right to claim compensation for breach of a repair obligation, for example, it's within the power of the courts to vary the possession in order to restore the trespasser's tenancy, and so to enable the claim to succeed. In this way, the provisions in paragraph 21 mirror the position in relation to tolerated trespassers. However, where the courts use the power in paragraph 21(3), this is only for the purposes of the claim. It does not restore the tenancy status for other purposes. So there again, carefully, what is thought appropriate to have is a carefully crafted solution to the problem, which is a discretion, but restoring the tenancy only for the purpose of the claim for damages under the repairing covenant.
So that's not exactly the Rogers solution, is it?
No, it goes exactly, and it's seen as advantageous that it's not exactly the Rogers solution. The Rogers solution, unless the Lord Justice Simon Brown, as he then was correct to say that you could attach conditions, and that was controversial in argument in Knowsley, not by me. Then you simply restore the tenancy with all the incidents of the tenancy. But the paragraph 64 solution is consistent with the whole thrust of Schedule 11, which is that you don't have a full retrospective revival of the tenancy. Instead, Parliament has selected the purposes for which there is to be a degree of retrospection. And I don't offend. Case really is a complaint that Schedule 11 doesn't deal with this situation. That is true.
Yes.
And then the final part to draw attention to on the guidance, paragraph 68 says, since this is a complex area of law, Part 2 provides the Secretary of State and Welsh ministers with the power by order to make further provision with respect to some of the details in Part 2 should the need arise. And then there's some discussion about whether there should be any divergence between English and Welsh rules. And the answer is no, but in general that's not desirable. And then Annex A, which is page 30 of the document, lists the circumstances in which orders can be made. 8 order-making powers in Part 2. The last of them is Roman 8, which enables an order to be made to provide that the provisions in Part 2 of the schedule apply to successor landlord cases. That's paragraph 24.1. The last of these powers being exercised in the successor landlord order, and Schedule 11 as amended as modified by the order in relation to successor landlords immediately follows in the guidance. The guidance says there are no plans currently to use any of the other powers. So what Parliament is doing there is saying, well, we think we've identified the positions where modification of the situation in the period before the new tenancy needs to be made, but there are a series of order-making powers to fine-tune the situation if it's thought to be necessary. Now, once again, that ability to fine-tune will be rendered entirely nugatory by a decision simply to reverse boroughs.
Well, it would be rendered unnecessary, really, wouldn't it?
Yes, you can choose your adjectives. It wouldn't be operable.
No.
Well, you're saying it wouldn't be fine-tuning, it would be a blunt instrument, wouldn't you?
That's exactly what that is exactly what I'm saying.
Yes.
I mean, that's the whole thrust of all of these submissions. You only have available, you, the court, only have available the blunt instrument. Parliament has available an ability to fine-tune. And I repeat, in cases where the practice direction is in play, the court has a choice about whether to use the blunt instrument or to recognise the fact that problems will have arisen in the intervening period in reliance on a case law that ought to be dealt with by fine-tuning.
We're going to have another look at the consultation process.
Yes,
I don't want to take it out of
certainly
order particularly, but I would like to see, I must say, having taken the point that the options as identified were either status quo or a complete rewriting, which we saw in that little table as refined. I'd like to see where matters went from there. That's certainly one of the matters I was going to do at this stage. If your Lordship's go to Volume 4, Tab 52. Yes.
Your Lordship's look at page 29. sorry, probably better to start at page 25. I'm sorry if I've got your note wrong, but the description of the options starts at page 25. And option A is do nothing. Text says this is the baseline against which the costs and benefits of options B, C and D have been assessed. It represents a continuation of the existing ways of dealing with tolerated trespasser issues, which have cost implications for tenants, landlords and the court service. A number of reasons we do not consider this to be a viable option. The existence of tolerated trespassers creates the problem of loss of tenancy status, usually without tenants' knowledge. Problems arising from the loss of tenancy status include, and then the first of them that's listed is in fact succession rights. And then right to exchange, contractual right to repair and maintenance of property for secure tenants, unlawful increases in rent, voting rights. Now, all of those are addressed in Schedule 11. Succession rights only by providing there's only one succession, there can only be one succession, but there they are. Option B is amending the 1985 and 1988 Housing Acts to deal with tenants subject to future possession orders, and that's then described more fully. Then option C, which was the government's preferred option at this stage, was amending the 1985 and 1988 Housing Acts to deal with tenants subject to future possession orders and restore tenancy status to all existing tolerated trespassers. 10. This option proposes the restoration of tenancy status for all existing tolerated trespassers and prevents this becoming an issue for any tenants subject to possession orders in the future. Then if your lordship, my lady, go on to the response, which is at tab 53, the following tab, is a summary of responses to the consultation on tolerated trespassers. The responses to whether there are alternatives in paragraph 8. Paragraph 8 says a small majority of those who answered this question felt that there were no alternative solutions to the problem of tolerated trespassers other than those set out in the consultation document. However, only around 45% of the responses addressed this issue. A small number of responses expressed the view that it was unreasonable that tolerated trespassers should have all the benefits of security of tenure. For example, it was proposed that consideration was given to denying or suspending any right to buy application from the date of possession until the date the tenant leaves the property. I'm suggesting that some respondents are unaware that the right to buy is suspended when a respondent is in place. And then paragraph 9 deals with compliant trespassers. And then, importantly, paragraph 10, should the legislation be amended to restore the tenancy status of all existing tolerated trespassers, i.e. those still remaining in their homes, more than 90% of those who replied to the consultation exercise expressed an opinion on this question. Responses were split roughly 2/3 to 1/3 in favour of legislation to restore the tenancy of all existing tolerated trespassers. The strongest support proportionately came from the judiciary, consumer groups and legal academic groups.
I've lost you, I'm afraid. I was looking at the executive summary, paragraph 10, but we're looking at something else, are we?
I'm in the text of it. Sorry, my lord.
It's page 12.
It's page 12.
Page numbers
My
at the
fault.
top of the page.
Yes, thank you. Yes, thank you.
So these are actually, as I understand it, setting out the questions that were asked in the consultation.
Yes.
These are the summary of the responses. Yes. Paragraph 10 is important. More than 90% of those who replied to the consultation exercise expressed an opinion on this question. Responses were split roughly 2/3 to 1/3 in favour of legislation to restore the tenancies of all existing tolerated trespassers. The strongest support proportionately for this came from the judiciary, consumer groups and legal academic groups. Those who opposed legislation did so for a number of reasons. Some respondents took the view that it was not the legislation which was defective, but the court form. Others were concerned about legislating retrospectively and felt this posed too great a risk to landlords in terms of liability claims from current and past tolerated trespassers. One respondent suggested an alternative would be somehow to reinstate a tenant's rights without reinstating the tenancy itself retrospectively. Pause there, that's pretty well what happened.
I wonder who it was.
I don't know.
Clever idea.
It was also suggested that since restoration of the previous tenancy would have no effect on the possession order, which would remain in force, there would be no longer the justification for issuing possession orders without a fixed date. Finally, it was argued a better approach would be to amend the Housing Act to overturn the London and Quadrant against Ansell decision. And then 11, if legislation is amended, should provision be made to protect landlords from liability for damages? If so, in what circumstances and how might this be achieved? Respondents who answered this question, about 70%, were virtually unanimous about the legislation to protect landlords from any liability arising out of claims arising from the restoration of tenancies to tolerated trespassers. Some questioned how, in view of the fact that any landlord action would have been taken in compliance with the law at the time, any claims for liability against them would be successful. However, the prospect of historic possession decisions being revisited raised significant concern amongst some respondents, who questioned whether it would be possible to legislate in such a way that it would be entirely claim-proof. And so that, in a way, that's one of the issues where that might arise, is the successor the person who would otherwise have been a successor who is left. One can see that any claim by such a successor would be difficult. I mean, one might well feel it would be lost because he wouldn't now be able to maintain it. He now satisfied the tenant condition. But history teaches that it may be unwise to deal with that. But the most important point is dealing with liability for damages. The respondents who answered this question, and 70% of those respondents did answer this question, that 70% were virtually unanimous about the need to protect landlords from any liability arising out of claims resulting from restoration of tenancies to tolerated trespassers. Now, it's clear from what we have already seen in the guidance that response caused the rethink to introduce the mechanism of paragraph 21(3).
There's a list in the annex of the respondees, as they're called. It looks at a very quick glance about 70% of them probably are landlords.
Well, I'm quite sure that the concern was being expressed by landlords. Yes, I think it would be naive to suggest otherwise.
Ultimately, the pivotal factor seems to have been the acceptance by the government that it would be difficult to make these actions, these possible actions, claim-proof.
Yes. Yes. I mean, most obviously with repairing covenants, where in order to meet the concern that we've just been looking at, the government responds by statutorily enacting Lambeth and Rogers effectively. I know it not quite in the precise form. But then, in order to produce certainty in relation to various other claims that might be quite difficult to think about, you avoid the problem by ensuring there isn't full retrospective restoration of the tenancy.
But if one is confronting the dilemma, do you confirm an interpretation, say, for the sake of argument, that you consider to be the wrong legal interpretation? Do you confirm the decision of Thompson and Burroughs on, let's be frank about it, essentially pragmatic considerations that if you don't do that, you're going to give rise to all sorts of difficulties. And then one sees that when confronted with the alternatives, the government indeed consulted first of all on the basis that that's precisely what it would do by legislation, but then opted for an alternative because of what it apprehended or was persuaded to apprehend would have been the difficulty in protecting landlords. The question is, what is the position of the court in all of this? I mean, let us say, as I say, the premise is that for the sake of argument, we consider that the Thompson interpretation was wrong.
Yes. Well, in my submission, this is there is always an issue for the court, particularly the highest court, but more generally for the court, in deciding whether or not to reverse a long-standing line of authority that has been acted on. It's, I mean, plainly, if the logic is simply impossible, if absolutely clearly wrong, the earlier decision, then the court may feel it's obliged to reverse it, whatever the practical consequences. But we're not in that situation. I'm going to be making some submissions that actually the only possible reading of 82.2 is the reading that led to Thompson and Elmbridge. And I note that Mr. Luber hasn't actually put forward another construction of the words, so it's quite important to realise that. One has to grapple with the wording in some way. But once one's in a situation where there's a decision which has been accepted as correct on the wording, albeit with unfortunate practical consequences, then the court has to decide whether or not to use the freedom granted by the practice direction to depart from the decision or not. And my submission is no more than these practicalities are very obviously highly relevant to that decision.
I happened to notice this morning that in a case called Rees and Darlington Health Authority, Lord Steyn in 2004 deals at some length with the question of where the practice direction stands now. And also, it's not only, I think, if the law is very long-standing, because also, if, as it then was, the House of Lords had recently considered the question, then there was a very strong disinclination, it was said, to move away from it, even if the previous decision had been 3-2.
Yes, there was some discussion of it in the two cases called Lambert and Kansal, where this came up, and a question of looking again at a very recent decision in the area of human rights.
Yes.
And the House really decided not to go back, although I think there was a majority view that the earlier decision probably was wrong.
Was probably wrong, yes.
I mean, there's been a later, Horton and Sadler, 2007, one appeal case is 307, where this House did, in fact, eventually overturn precision forgings. But there was some discussion in that case. Lord Bingham set out his views. And then, although the Privy Council doesn't attract the practice statement, it's called, as such, we divided 4-3 in a subsequent case. Well, who was it? There's nobody who was in there. The name of which I've forgotten. But I mean, where we did discuss the matters too, but that was a very different factual scenario.
Yes.
I mean, we sat 7, all 7 agreed that the Privy Council 3 years earlier, sitting 3-2, were wrong, but we divided 4-3, 4 of us saying that in those circumstances we should, but 3, including one who had been in the minority, but in the earlier case said, even so, you shouldn't do it. But,
yes, well, that's very similar to Kansal, except it went the other way.
Yeah, that's right.
Yes. I mean, there plainly are these considerations which arise absent a tidying up statute, if I can put it like that, where the court is being asked to reconsider a fully argued but recent decision.
I mean, you could perhaps say that not only have you got the Burgesses case, but actually, more recently, you've had, true, it wasn't argued to the contrary, but you've had the further case of those.
Yes. And
there will have been yet further people organising their lives on the basis even of that.
Well, absolutely. We have Knowsley, we have Lord Newburgh drawing back, we'll come to it in a moment, from positively holding that Burroughs is wrong, partly on the basis that that Schedule 11 is in existence. So it really is a very strong position. I mean, that's the point we make in the case, that the only sensible way of looking at the law, if you were advising at this stage, unless you were considering the possibility of boroughs being overturned by the court in these proceedings, would be that the tolerated trespasser saga has been put to bed by Schedule 11, with all the attributes of the settlement that's in Schedule 11. Because you read both Lord Neuberger in Knowsley with the provisions of Schedule 11 itself.
Well,
Yeah.
is there anything more to make of this?
No, that's the guidance.
That's your answer to issue 1.
Well, can I just... Yes. Can I just make, without necessarily taking your lordships through the material, Lambeth and Rogers is at tab 21 in volume 2. Perhaps I just, for your lordships' noted subsequent consideration.
Did anybody think it worth mentioning? I can't remember in Knowsley.
Yes.
It was mentioned.
It figured to quite a large extent, not in Knowsley itself, but in Hunnigan Green. Your lordship may recall, I was acting for Mrs. Hunnigan Green. She was claiming the right to buy. The issue was whether her existing application for the right to buy could be revived by the Lazarus order. Answer, yes. And Rogers was in play. Rogers was a central part of my argument in that case. And your lordship may recall that...
Well, you're sure, I mean.
Yeah. In any event, the passage that's relevant in Lambeth and Rogers, or two passages, first of all, page 369,
This is Lord Justice Mummery.
Lord Justice Mummery saying there was no realistic attack, or any attack at all, on the exercise of the judge's discretion to revive the tenancy in Miss Rogers' case. He says no error of principle in the judge's exercise of his discretion, nor can it be said that it was plainly wrong. Parties have made an agreement that Miss Rogers would not be evicted if she kept to the agreement. She kept to the agreement, was treated as compliance with the terms of the order. Judge took the agreement into account, so on. He also took into account the fact that the secure tenancy would be revived by an order under section 85(2)(b), and that in consequence the council would become retrospectively liable to her under the repairing obligations. Did not leave any relevant factor out of account. And then my Lord Justice Simon Brown said, the critical question facing the judge below, second paragraph, question which has simply not arisen in the earlier cases, is whether or not to allow Miss Rogers to claim damages in respect of the disrepair of the premises between December 1992 and April 1997, i.e. during the limbo period. A Housing Act provides mechanisms where either result could have been achieved. By making the unconditionally order he did under section 85(2)(b, the judge revived the previously determined secured tenancy with retrospective effect. He could, however, have made the order by virtue of section 85, subject to a condition, see section 85(3)(b), that Miss Rogers' damages claim or part of it should not be pursued, or he could instead have made an order under section 85(2)(a), which would have left Miss Rogers as a tolerated trespasser. And then it's plain from the remainder of the lordship's judgment, and in particular, if your lordships and my lady look in towards the end of the second paragraph on page 371, Your Lordship said, but without the benefit of the agreement, indeed 7 months satisfactory compliance with it, she could hardly have expected to succeed upon such an application. That's an application under 85(2)(b). And this point surely is the answer to Mr. Tager's complaint, that as a result of this case, local authorities will not in future allow defaulting tenants a second chance, lest they are thereby held liable for breach of backdated obligations. So your Lordship is, as I understand it, saying that if you're still in breach of the conditions of the order, that's a highly relevant fact as to whether or not you're going to make the Lazarus order, whether or not the court is going to make the Lazarus order.
And I think Lord Newberger referred to that in paragraph 83 of his speech in Knowsley, and said that he thought there was a very strong case that Lord Justice Simon Brown was right on page 271.
I remember the debate, but I couldn't for the moment remember the outcome.
Very happy reminder of that. Paragraph 1.
83.
Yes, well, I was going to go next to Knowsley. We've seen all the passages I rely on. I just put them in the context of this submission.
Yes.
Tab 18, volume 2.
Same time. Yeah.
There's a passage which runs from paragraph 72 through to 74, which is important in connection with my submission, that Lord Newberger accepted there was an important practical distinction between assured tenancies and secure tenancies. As your Lordship will see that in the middle of paragraph 73, he says there will undoubtedly have been tens of thousands of cases in the county court, indeed many negotiations, much legal advice and many actions involving secure tenancies which also proceeded on this assumption, i.e. the assumption that Thompson and Burroughs are correct. And then first sentence of paragraph 74, until 2007, however, there had been no case, at least in a court of record, which involved considering the question whether the reasoning or conclusion in Thompson as improved in Burroughs applied to assured tenancies. So when the Court of Appeal in Knowsley, when the appeal in Knowsley came before the Court of Appeal, it was an open question whether an assured tenancy ended as soon as the tenant failed to comply with the suspended order. So that's the contrast between tens of thousands of cases which have proceeded on the basis that Burroughs is correctly decided, and this decision being made for the first time in Knowsley itself in the Court of Appeal. Well, then paragraph 91 through to 93 he explains his approach to Burroughs. Now, 91, which I'll come back to in a moment in my final submissions on issue 1, is the only place where in this hearing any attempt is made to actually construe what section 82(2) says. And it will be my submission with respect in a moment that the construction doesn't work. But what he says is, however, it should be added that I strongly suspect that if the point had not been determined in Burroughs, I would have reached the same conclusion in relation to section 85 of the 85 Act as that which I've reached in relation to section 9 of the 1988 Act. There's a powerful case for saying that, quotes, the date on which the tenant is to give up possession in pursuance of the order in section 82(2) of the 1985 Act can and therefore should mean the date specified in a warrant of possession which is duly executed or acted on by the tenant. And then he makes an in section 121 point, which is arguably inconsistent with the language of 121. And then we've seen the passages in 92 and 93, but records Mr. Luber with my support and Mr. Arden's support and Mr. Underwood's support saying simply too late to take that course. and repeating the view that Thompson had been assumed to be right and has been acted on in many tens of thousands of cases over the past 20 years or more, particularly since it had the express approval of your Lordship's House more than 12 years ago. And then he refers to the parliamentary material, in particular Schedule 11, and in my paragraph 93, in my view, we should not reconsider the view expressed in this House in Burroughs that Thompson was rightly decided so far as secure tenancies are concerned. And then the reasons are, in the absence of any submission to that effect from the bar, in the face of discouragement from counsel who are highly experienced in the field, it would be wrong for this House to effectively go back on its previous approval of a long-standing decision which had been acted on in a plethora of cases where there is in place amending legislation having the same effect as such a reversal, in which Parliament has decided to amend the law only prospectively.
It's an interesting passage because he's tempted to nibble at the point, isn't he?
Yes.
And then he draws back from it.
Yes.
But having explained why he doesn't want to pursue the point any further, it's not surprising he doesn't actually go further on to examine the point than he does in paragraph 91.
I completely agree with that. But your Lordship, he does earlier in the judgment, an important part of his conclusion on assured tenancy is recognise many of the practical problems that the doctrine recognised by Burroughs has given rise to. And your Lordship will understand I'm not submitting that there haven't been practical problems. That's not my case, is to suggest that those practical problems don't exist. My case is, first of all, this point about not departing from Burroughs. But the second point is the point I'm just going to come to, which is that the drafting, the construction suggestion in paragraph 91 doesn't actually work. And if I just invite your Lordships to have section 82.2 available in whatever form.
Well, it's probably easiest in tab 42. It's volume 4, tab 42, isn't it?
Yeah. It's obviously set out earlier in those days. I was just wondering whether we could do it. Now, the position in which the construction advanced by Lord Neuberger is, with respect, very difficult to operate, is a situation where there never is a warrant for possession, which is not impossible, quite common. The court makes an order, the tenant leaves, say, a month after the date specified in the order, voluntarily, without there ever being a warrant. When, in those circumstances, I ask rhetorically, does the tenancy come to an end? Now, the natural and absolutely straightforward reading of 82.2 is that the tenancy ends on the date on which the tenant is required to give up possession in pursuance of the order. It is to give up possession is the language of inviting the person making the decision to make a judgment at the time of the order. When is the tenant required to give up possession in pursuance of the order, or is to give up? I've inserted again required into that.
So the choices really are either, is it either is required, or is it just simply looking to the future? When is it actually going to happen?
Well, I think Lord Neuberger's approach requires a retrospective judgment when it actually was given up, and that is, the choice probably is between the date on which the tenant is required to give up possession in pursuance of the order, which I say is its natural meaning, or Lord Neuberger's construction, which I think has to be gives up possession. So you make the judgment retrospectively.
Instead of he is comes to give up possession.
Yes.
Either he's forced out or he goes out.
Yes.
Of course, on one view, is required to give up possession could mean where the order has been executed and is therefore required to give up possession.
Yes. I mean, if you have paragraph 91 beside section 82, one can see that without straining too much, if a warrant is issued, that will specify a date on which the bailiffs are going to arrive and execute the warrant. So, without doing much damage to the language of 82.2, you can see that in that situation, the date on which the tenant is to give up possession is the date specified in the warrant, rather than the date specified in the order. That's a small step. Well, in fact, it's not because the warrant is still in pursuance of the order. But in my example, you never have a date, except the date in the order, except unless you construe 82.2 as meaning, Lord St. Van says, the date on which he comes to give up possession, or gives up possession. And my very simple point is not what it says. Now, I don't need to go as far as saying that construction is so clearly right that for that reason alone you shouldn't depart from boroughs. What I do say...
What about 82 is talking about being brought to an end by a landlord. But tenants can bring tenancies to an end as well. So, I mean, secure tenancies come to an end if the tenant departs, gives notice to quit, don't they?
They do. Well, if they move out, they certainly cease to be secure.
They do because they're no longer occupying, yes.
Well, they don't fulfil the tenancy condition.
But by operation of law, if they're not there,
yes,
it isn't a secure tenancy.
Yes.
So that may be the answer to your example.
Of course, the whole thrust of the section as a whole is dealing with security of tenure, isn't it? And it's really contemplating a situation where the tenant wants to remain on in the face of what the landlord may want to do, and the landlord has got to take certain steps in order to change that.
What I'm dealing with is a situation where he's taken those steps.
Yes.
The court has recognised that he is legally entitled to possession.
Yes.
You then have to decide, in accordance with the statute provisions, when the tenancy relationship ceases. And my submission is simply that the natural language of 82.2 is that when you're in the opening words of 82.2, that is, the landlord has obtained an order for possession, it's 82.2 that tells you when the tenancy comes to an end.
Yes, but it has to be read, perhaps, in the context of 82.1, which is the prohibition on the landlord bringing the tenancy to an end.
Mm-hmm.
That's the contrary argument, Mr. Travell, because otherwise, all you have is not the tenancy ending, but the security ending.
I agree there's a contrary argument.
If the tenant leaves, and all these these tolerated trespassers who left the premises for all sorts of good reasons, tenancy didn't end.
Is your point really that Lord Neuberger's interpretation is incomplete? And he envisages a situation which, of course, one can easily envisage where a warrant is actually issued, but is incomplete because it doesn't cover the situation you've envisaged of a tenant going without waiting for a warrant to come.
I think my point is that his explanation is a reading of the wording which doesn't work in my example. Baroness Hale is right, then it's incomplete. There's another way in which the scheme can be made to work. But Thompson and what we're discussing is whether Thompson and Elmbridge and Burroughs so clearly wrongly decided that your lordship should depart from them. I do know more than say the natural reading of 82.2 is to say that it does indeed specify a date on which the tenancy comes to an end, which isn't simultaneous with the vacation of the building. Could have been, but it isn't.
I suppose your end stop is that it's at least a tenable interpretation.
Yeah.
And given the imperative of all of the factors that you've outlined.
Exactly. I mean, I think that's the best way of seeing my case, is that one gets into the territory of the factors that I've outlined, because one can't simply dismiss Burroughs and Thomson and Elmbridge as a judicial aberration, as it were. They are giving effect to the natural meaning of the words.
I mean, I think the recent jurisprudence makes plain that the more obviously wrong the court thinks the earlier construction was, the readier it'll be to depart from it, which is not a wholly surprising proposition.
No, indeed. Indeed. Just to complete that picture, I won't invite Your Lordships and my lady to go back to it, but it's important to bear in mind that Lord Jauncey, certainly in careful reasoning in Burroughs itself, adopted the approach I'm now advancing to 82.2. And I think it's fair to say that despite the explanation for 85.3's reference to mean profits as an example of torrential drafting, if I got the phrase right, yes, and which may well be correct, one cannot say that the construction of a statutory scheme which includes 82.2, which has the natural meaning that I refer to it, in a scheme which also includes 85.3, i.e. contemplates a situation where there will be tenants, ex-tenants in possession, in the premises, still paying mean profits, is obviously wrong or should just lightly be put aside. Fully aware, of course, of the explanation that Lord Neuberger gives in Knowsley for the reference to mean profits.
Where do we find that?
If we go back to page 1.
Is it 87?
Yes.
Yeah.
And the reference to torrential drafting is in the opening words of 88.
Yeah.
And I think this point comes down to this, that Lord Neuberger was able to deal with the reference to mean profits in the insured tenancy regime, partly because there simply wasn't an express provision like 82.2 to deal with. Once you've got 82.2 in play, then there is a situation in which somebody will be paying mean profits if my construction of 82.2 is correct.
Perfectly logically, as he says.
Perfectly logically. Yes. Yes. But none of this is to defend the Thomson and Elmbridge and Burroughs line of cases as producing sensible social policy results. I'm not endeavouring to do that. As I do say, the problem has been addressed by Schedule 11, and Burroughs isn't so plainly wrong that the court should just put it to one side. I think yes, those are my submissions on issue 1. Overnight, I looked at the case that Baroness Hale mentioned, which is Bakewell. We have copies of that available if it helps, but
yes.
It is a different, the principal point I make is a different situation, because one is dealing with the first time an issue reaches the Lords.
True.
And that the drafting of section 98, I think it is, that produced the new regime, doesn't have the sort of elaborate safeguard features that Schedule 11 does in our case say. And I think I can say that if one looks at the argument in Bakewell, the issue of what to do about section 68 it is, I don't know why I'm calling it 90, section 68 of the 2000 Act only appears in passing in Mr. Morgan's reply at page 531. opinion at paragraph 6, Your Lordship explains by, to use the opening words of paragraph 6, section 68 of the 2000 Act was enacted in order to deal with this problem, but it did not provide a complete solution to it. And then the Lordship describes it.
But 531 was responding to Miss Williamson at pages 527 to 528, wasn't it?
That up.
Yes, bottom of 527, top of 528.
527H, I'm grateful. I thought I checked for that. Well, actually, I hadn't picked that up. I had looked through it and not found it. But it's not my point. It's the point that as a matter of statutory construction, section 68 helped her. Which isn't my point. My point is the role of Schedule 11 in influencing Your Lordship's and my lady's decision to depart from the established line of case law. And there's a further, just to complete the picture, in Lord Scott's speech at page 535F, paragraph 21, he refers to paragraph section 68 and then says at the very end, but of course, if the appellants can satisfy Your Lordship that the decision in Hanning's case is wrong, they can establish their respective rights of access over the common without having to rely on section 68 or to pay Bakewell anything. And that's, I think, probably be proved wrong again immediately, but I think the full extent of the references to section 68 in the judgment.
Well, he was clearly rejecting the argument that Miss Williamson had put forward.
Indeed.
Which was an extreme version. I mean, your situation is different.
Yes, very different.
Your situation is one where Parliament has actually legislated to reverse the effect.
Yes, to reverse the effect.
Of the decision of which it didn't like, whereas Section 68 was legislating to accommodate the effect. Make it less draconian.
No.
Well, thank you very much.
Those are my submissions on issue 1. Issue 2, I propose to take shortly. We agree with Mr. Luber that the crucial question is whether, as a matter of statutory construction of the 88 Act, 85 Act, sorry.
Could you say that again? The issue is what?
Whether, as a matter of statutory construction of the statutory scheme.
Yeah.
You mean the 85 Act?
I mean the 85 Act, that's what I was studying for a moment.
Yeah.
You mean Section 85(2) of the 85
Well,
Act?
it's the whole scheme, isn't
Yes.
it? I mean, I did mean to say the whole scheme, otherwise I would revert to the same, simply saying Section 85(2).
So it's the whole scheme, really.
It is the whole scheme. The right to apply under Section 85(2) is a right that's capable of transmission by either will or on intestacy. And our submission is that if we're right about boroughs, so that the court is approaching it on the basis that the true construction of the 85 Act is that the tenancy ends at the moment identified by 82(2), that is the date specified in the order, it is clear that the scheme does not contemplate anything surviving that can be transmitted to the estate, or indeed to anybody else. I can ask the court to go to paragraph 24 of our printed case. we make the point that the apparent attractiveness of my learned friend's argument depends upon the assumption that the right to make the application under 85(2).
Sorry, you're dropping your voice.
Sorry. We make the point that the right, that the apparent attractiveness of my learned friend's case rests on the assumption that if he's right about the nature of the right under 85(2), it will vest on death in somebody who is likely to make the application on behalf of the successor. But we see no basis for that assumption at all. It's the right, if it is capable of transmission, will vest in accordance with the will or in accordance with the rules on intestacy. There is absolutely no reason to assume that there is likely to be an identity of interest between the person who takes on intestacy or under the will and the successor. It's quite likely to be, because they're going to be part of the same family, often. But it's by no means obvious that that is the case. One can imagine a relatively simple will, leaving all my estate to my mother. Tenant has been living with his brother for a long period of time. Mother may feel, well, I wish to make an application on behalf of the estate to revive the tenancy. May not feel that. And, the problem is that the problem is that there is no reason to make the assumption that it is absolutely implicit in my learned friend's case. And the facts they presently stand, the estate is no doubt vested in the public trustee, because as I understand it, Mr. Alan Austin died intestate, and there's been no personal representative appointed. So the person on my learned friend's argument with the right to make the application is the public trustee. Now, it's very difficult to see what policy basis, on what basis the public trustee, should decide whether or not to make the application.
Well, the public trustee is not a personal representative.
No.
The public trustee is simply the recipient of
the
assets
estate,
which would otherwise not have a home. And as I mentioned yesterday, in this sort of situation where we're dealing with people who are not well off, they can't pay their rent, they're not the sort of people who go to solicitors and make wills and appoint executors.
Indeed.
And the natural course, which is very natural, not at all surprising, the surviving brother, who is the one who is living there, applies to the county court to be appointed to represent the estate. I mean, that's entirely natural,
Yes.
not unusual.
I'm not suggesting the opposite for a moment. I can completely understand that can happen, and no doubt commonly, very commonly, does happen. But equally, that's because of the family structure of the family concerned. The position could well be that someone else is the obvious personal representative, or that if there's a will, the estate has gone in a very different direction. All of this is just introduction to try to suggest that it would be rather surprising to find that the statutory scheme did envisage that the right to make the application under 85(2) devolved on intestacy or in accordance with the terms of a will, when it's crystal clear that the rest of the scheme is designed to ensure that the rights that are protected are the personal rights of the secure tenant, gained by the fact that he satisfies the tenant's condition.
Sorry, I missed that last few words. Could you say again?
The rest of the statutory scheme is crystal clear that the rights that are protected under the tenant are the personal rights of the tenant derived from his status as a secure tenant, satisfying the tenancy rate, the tenancy condition. There being no possibility of that right being capable of transmission, as I'll show your lordships in a moment, but it's an axiom of my learned friend's own case that the security of status as a secure tenant cannot be transmitted except in accordance with the terms of the statute itself.
So you're placing a lot of reliance on Section 81?
Well, I was placing reliance on the whole scheme.
Yes, but the creation creation of a secure tenancy comes through the coincidence of the landlord condition and the tenant condition.
Yes.
The tenant condition is a very individual, personal thing, is what you're
Yes.
saying.
We'll come on in a moment to the provisions dealing with assignment and with succession. But it's possibly important to distinguish between the property rights that arise from the tenancy, seems it's simplest in a fixed-term tenancy. Those property rights are plainly, as property rights, capable of transmission by will or on intestacy, and the statute envisages that that is the case. We'll come to it in a moment. The status of protection as a secure tenant is a personal status which arises from the fact that the individual fulfills the tenancy condition.
But equally, the status of a successor for the purposes of the Act doesn't, as you yourself have been emphasising, in any way depend on rights under a will or intestacy. It
Indeed.
depends on satisfying the statutory conditions. And one of the statutory purposes is to provide protection for a successor as well as for the secure tenant while he's alive.
That is entirely true. But the learned friend has to face the problem that if Burroughs is correctly decided, the statutory scheme envisages deliberately that there is nothing to vest in the successor. There is no secure tenancy at the moment of death. That's why he has to argue that the right which appears to be associated with the security provisions is capable of being transmitted by will, as opposed to simply not existing at the moment that there is no secure tenancy. It's our relatively simple construction.
And what about Section 90? This is the term certain.
Right.
I mean, we looked at that briefly yesterday. You've got a situation where the tenant dies. He's a tenant, of course, while he dies, and the tenancy is for a term certain.
I read it here. Yes, I'm going to come to that. Section 90 and Section 91 are, in my submission, entirely consistent with my case, because what they make it plain is that what cannot devolve, except in accordance with the provisions of the statute itself, is the status of security. That's what Section 91 says. Sorry, Section 90, subsection 1, applies when a secure tenant dies and the tenancy is a tenancy for a term certain. It remains a secure tenancy until it's vested or otherwise disposed of in the course of the administration of the tenant's estate, or mentioned in subsection 3, and then it ceases to be a secure tenancy on being vested or otherwise disposed of in accordance with the administration of the estate, unless it vests in either in accordance with the Matrimonial Causes Act or in a person qualified to succeed to the tenant. So that's drafted on the assumption that there is a property right, the term certain, that is capable of being devolved by will. If, in accordance with the will, it ultimately vests in someone who is qualified to be a successor, then the statute says that the tenancy continues to be a secure tenancy throughout that process.
Well, I'm sorry, I don't, under Section 90, subsection 1, I mean, if a tolerated trespasser, albeit that he's got a tenancy for a term certain, dies, I mean, I understood you to be saying you're not a secure tenant.
If you're dealing with a tolerated trespasser, sorry, if you're dealing with someone with a term certain, you won't be dealing with a tolerated trespasser. They're going to be there under the term certain. So 90 won't actually be in play.
Sorry, you can't have a tolerated trespasser under a term certain?
Well, not if the term certain hasn't been terminated.
But the term certain is going to be subject to the ordinary clause for forfeiture and re-entry, isn't it? I mean, we've got to assume that was part of Parliament's intention.
Yeah, yes. Well, if that's the case, then if that's the example that's being put, the term certain has already been forfeit, then we have the same problem that we're dealing with in the present case, which is that Section 90 doesn't apply because there is no secure tenant at the moment of death.
So the opening words of subsection 2 couldn't apply then?
And then the opening words of subsection 2 couldn't operate because you're not within Section 90 at all, because you're not a secure tenant.
That was a very helpful intervention.
By me.
Well, the answer may or may not be helpful.
Mr. Wilbur was making a rather more general point, I think, really, that this is a scheme which does envisage transmission, admittedly, to certain individuals, people who one can see identified in subsection 3 of section 90, for example. And it then looks rather strange that one should cut it off in the situation we're contemplating in section 85. And he says why. It doesn't mention death. It doesn't actually do that at all. It doesn't say anything terminates particularly on death, and the thing should be given a sort of purposive construction, as it were, to fit in with the way the other sections work.
Well, the answer to that is that all his other examples are examples of a situation where the statute does deliberately produce the result that he wishes. In the transmission on death, where there is a secure tenant, is expressly dealt with by Section 90 and Section 91. Well, so 91 is dealing with assignment, but is dealt with by 91. Neither of those are actually in play if there is no secure tenant, because the tenant is dead. Or because the tenant was a tolerated trespasser at the moment of death, I mean. The other example that he gives is the example in 85.5. An individual can, other than the tenant, can make the application under 85.3.
I missed the reference. It's section
85.5.
Yes.
As it originally stood.
Yes.
He is, I think, saying, well, the statutory scheme envisages that someone other than the tenant can make the application under 85.2.
Presumably
That's
after
true.
the death of the tenant, or not?
No, this is section 85.5.
85.5 certainly isn't expressly dealing with that.
No, it's not dealing with that really at all.
It's typically the case where the husband is simply left home,
Exactly.
and the wife is left there.
Well, I appreciate that, but say the husband left home and dies. Well, is the wife then in a position to or not?
If she is, it is because 85.5 expressly says so. I mean, it doesn't deal with that because it doesn't actually say death, but she is, by statute, put in the same position as the secure tenant to make the original secure tenant, to make the application to postpone the date of possession. That's what 85.5 says.
Well, that means you can read subsection 2 in that way to allow her to do it under subsection 5, does it?
Yes, that may be right, but that doesn't assist in the present problem because 85.5 simply has no operation in the situation we're dealing with.
I mean, you have to say that if the tolerated trespasser applies and goes to court, but he hasn't quite got his judgment and dies, that's it.
Yes, I do have to say that, but I do say that. When an offender is not making a submission that anybody can make the application under 85.2, or 85.3 rather, and that such a submission would be plainly misconceived in my submission. It's as he himself says, the ability to make the application is an adjunct to the original secure tenancy. It's designed to secure the rights of the secure tenant. We're not faced with a submission that the person as a successor can, as a result of that status alone, make the application. So he has to construct an edifice in which the right to make the application can be disposed of by will or on intestacy. And he has to do that. In our submission, that's just inconsistent with the scheme.
But it is possible for the landlord to apply under 85(2).
Yes, but the landlord will meet the landlord condition in section 80. Yes, sorry, it isn't there. In this clip, it's in the appendix. The landlord meets the landlord condition, so an application by the landlord is an obvious adjunct of the statutory regime.
The spouse would have the right under subsection 5 even after the tenant's death.
Well, I'm not answering that one way or the other.
But why not? Why not?
It doesn't rule it out, and there are reasons for thinking it ought to be permitting it to be done.
It certainly doesn't rule it out, and there are certainly policy reasons for assuming that it should be allowed under the scheme. But presumably we're envisaging a situation where proceedings have been brought for a possession of a dwelling house which is let under a secure tenancy. Husband then leaves, if that's the situation we're dealing with. Husband then dies.
Well, the odd thing is, husband then leaves. Section 81 is no longer complied with. There are oddities about Section 85(5). Husband leaves, tenant condition is no longer fulfilled. And yet wife is allowed to go to court and say, let's please suspend the possession order or discharge it if she can pay off the arrears or whatever. Quite interesting. Am I missing something?
No, I think that's right. But
very odd.
Our submission doesn't assist because 85(5) does exist. That's the fundamental point. There is no equivalent of 85(5) in the situation that we're presently dealing with. So when another friend has to say, well, the right must evolve in accordance with the general rules governing the devolution of the estate, and that produces the fundamental problem that I've identified, which is...
I suppose the only point I'm trying to sort of struggle towards, quite apart from trying to understand it, is that rather illustrates that there are circumstances in which this beast, the secure tenancy, has got a life of its own outside the presence of the original tenant. I don't mean the secure tenancy, 85(2), and for that matter, 4. Has got a life outside the presence of the original secure tenant.
But because 85(5)
You think it's
so.
only in 85(5) situation?
I mean, that is the answer.
We're looking at the whole scheme, aren't we?
You're certainly looking at the whole scheme. But what my learned friend has you've got to get as far as saying, Mr. Alan Austin could have made a will, I mean, it's highly unlikely, obviously, could have made a will saying, I bequeath to my Aunt Mabel the right to make an application under 85(2). There is absolutely no basis in the scheme for saying that it's possible to assign or devolve by will that right.
Does somebody have to make an application? Can the court not work?
Well, that was the point. In my submission, no. I mean, the issue has to be brought before the court.
Somebody would have to say to the court,
do it.
Look, I'm in this most unfortunate position. I mean, take the scenario we just had. The tenant, the trespasser, dies, having made the application before judgment. Can't his, you would say, unfortunate successor say to the court, well, come on, deal with this under 85(2).
Well, I mean, that's not my learned friend's argument. I mean, that's an argument. It's very deliberately not my learned friend's argument because it is an argument.
Why is it deliberately not his argument? What's wrong with it?
What's wrong with it is that you have to have some locus to make the application in the first place.
But who says you've got to make an application in the first place?
Well, it's got to be brought before the court. Somehow or other, the issue has to arise in front of the court. And short of somebody filling out an application form saying, I want this order and I'm entitled to it, or it is possible to give it to me because of my status as X or Y, you never get there.
But if a tolerated trespasser dies,
Yes.
it is not unreasonable. I mean, forget about beneficial interest and that. It is not unreasonable that his duly constituted personal representative, if he has one, or more likely a close relative appointed by the court to represent the estate, should have some sort of status in order to deal with the local authority landlord. I mean, that's reasonable enough, isn't it? There may be claims one way or the other for breaches of repairing covenants or rent or whatever. And if you once accept, which is not a very big step, that someone representing the estate can reasonably expect after the tolerated trespasser's death to be there talking to the landlord, well, it's not a very big step from that to say that the county court should recognise him as representing the estate for the purposes of 82(2), is it?
Well, it's a crucial step. I mean, he can only be recognised. He can only be representing the estate. It comes back to the fundamental question: if there is an interest capable of passing to the person representative.
I'm not sure about that. There's an analogy which will probably not be familiar to you at all, but it would be very familiar if you dealt with personal injury cases. For a long, long time, it was the case that if you were killed in a fatal accident, your estate had no claim. I mean, the law has now been changed. But Lord Campbell's Act, the first of the Fatal Accidents Acts, brought in the notion that even though your estate had no claim, that your dependents did. But the fact is that the normal plaintiff in an action of that sort was the personal representative, even though it wasn't an asset of the estate at all. That's just one example, but one very familiar in personal injury litigation, where you forget about beneficial interest. It's simply that the law recognises the personal representative as the person to bring this action.
But he's bringing an identifiable action. On your Lordship's example,
yes.
I understand what your Lordship is putting to me, that the dependents do have a cause of action.
They do.
And the appropriate way of getting that in front of the court.
Similarly, it might be said the successor has a statutory right to follow on the tenancy if you can get it reinstated.
But that's my Lord Brown's, I don't know necessarily proving it's wrong, but that's the same point as my Lord Brown's point, which is that there's nothing to prevent the successor, him or herself, appearing personally in front of the court in their own right to make the application. Now, we say that's contrary to the scheme. If it's not, then we don't need the edifice of the estate on the way to it.
Yes, that's what's rather worrying me, really. If one looks at if there are no express restrictions on who can bring the matter of 85(2) or 4 before the court, there may be some implied ones. It could be the original parties to the agreement, or the estate of the original party, one of them, if that was an individual, or it could be the wife, former wife, as we know, or why not the person who, if it were reinstated, would be entitled to succeed to it? Why can that person not do it?
We need to go back to basics. The reason where this argument is taking place is because the statutory machinery, which is designed to deal with succession, is drafted, if Burroughs is correct, on the basis that it does not apply in a situation where the the secure tenancy has already been brought to an end. So Section 89, which is the way in which the statute deals with the position, does not apply. That's the starting point.
But the going back point is that because of Burroughs or Thompson, we then have this creature of something that dies and can be brought back to life.
Yes, brought back to life in accordance with the machinery of Section 85,
Exactly.
which includes 85.5, but does not include any other provision enabling anybody else to make the application under 85.2. And the leadership's approach, 85.5, would not be necessary, because anybody with an obvious interest in the law generally could make the application under 85.2.
That was one of my reasons for asking yesterday, for the case that 85.5 was the response to, which I think was pen and done, but I haven't had time to look it up for myself. I know it was a response to a case, and obviously the reasoning which led to that conclusion that the wife couldn't apply after her husband had left her, although she'd got, as against the husband, the status of irremovability.
Well, whatever prompts 85.5, it is an answer to your ladyship's question.
It's the reasoning that led to the case that is what I'm
I understand the line of thought.
digging down to, yes.
But the fact is that if 85.2 is at large, i.e. anybody can make the application, then you don't need 85.5, simply redundant. But 85.5 is dealing with a situation where the spouse has rights under the matrimonial legislation, rights of occupation under the matrimonial legislation, would, on the sort of approach that your ladyship and the rest of the court are developing against me, would have an obvious status to draw to the court's attention the fact that it might be a good idea to revive the tenancy under 85.2.
Though her status is less obvious,
Yes.
less obvious than the successor status.
I mean, this is, if we're torrential drafting, may actually have a real point. That
The successor status is sitting there in the act, part of the scheme, contemplated, whereas the spouse or former spouse of the tenant is not part of this scheme, save for the purposes of succession.
Yes.
The reason it was necessary to drag her in this way was the decisions about what she was entitled to under the matrimonial code. Or not, as the case may be.
Yeah, I think I can't do better than say that the scheme of the statute is, in fact, that the succession takes place only where at the time of death there is a secure tenancy. That's what Section 89 says. And if Burroughs is right, the intended consequence of that is that there is no succession if at the moment of death there is no secure tenancy.
there is one. Sorry, I'm not interrupting you. There's other oddity that Mr. Luber drew our attention to yesterday, which is Section 91(3)(c). It's just an example of a situation that's envisaged where the tenant has actually died, and yet an assignment after death can take effect. There it is. I mean, it's Section
It's an assignment before death.
3C.
It's an assignment before death
Before death.
Yes.
to a person who would be entitled to succeed.
Mm-hmm.
In my submission, all of this is part and parcel of the same structure, that in order for this to be in play, you need a secure tenancy at the moment of the assignment. Indeed, if we're looking at it through Mr. Luber's eyes, rather than the more broad perspective that anybody can make the application under 85.2, 91 is in my favour because what it demonstrates is that security is not a matter that can be assigned except in accordance with the precise rules of the statute, which admittedly do include 91(3)(c). But you still need to be a secure tenant at the moment of assignment. Now, if you're looking at it from Mr. Luber's perspective, that is, you're looking to see whether or not the right to the application under 82.2 is capable of being devolved to the estate, either on necessity or by will. 91.1 is a very strong pointer against that in our submission, because what it makes it crystal clear is that you cannot assign during life a secure tenancy except in accordance with the terms of the statute. So, to repeat our view of the statutory scheme, is that one has a whole clutch of provisions which deal with the devolution of the secure tenancy. 87, 89, 90, 91. But all of them, A, demonstrate that secure tenancy cannot devolve except in accordance with the terms of the statute, and B, assume the existence of a secure tenancy at the moment of the devolution. And we say that following Burroughs is indeed the statutory scheme.
When did the reference to the Matrimonial Causes Act hop in? That hopped in between 1980 and 1985 as well, didn't it?
Yes, I don't know. I don't have the material to give the answer either, because I don't think there are notes in
No,
the
I'm not
appendix.
sure that it's possible to, except by looking at the 1980 Act, which is very different on this assignment point. And the only point I'm trying to make is that the family court held that a secure tenancy was property for the purposes of being able to make a property adjustment order, which meant that had then to be, or at least obviously somebody decided they didn't want to reverse that, it had to be accommodated in the assignment provisions. And I think that is one of the things that happened between 80 and 85, from recollection.
Yes.
So it's quite interesting seeing that at least one set of courts was looking at it as a secure tenancy, having enduring qualities, transmissible qualities.
The only difficulty with that is about the status of security. I mean, it's undoubtedly property. If the tenancy hasn't been terminated, i.e. the term certain hasn't been forfeit, or the periodic tenancy brought to an end in accordance with the provisions of section 82, then there's plainly property out there. The statute simply provides that it ceases to be a secure tenancy on assignment, or if it vests in the estate of somebody, if it vests in somebody following death who is not a successor, then it loses the personal status of security. No difficulty with that at all. But that's, in a way, my point. That all demonstrates the personal nature of the security, which is not capable of being transmitted by will or at all.
But my point was that if that were as simple as that, there would be no point in the court ordering a transfer of property under the Matrimonial Causes Act, because the moment the court ordered the person who had that personal status to transfer it to somebody else, it would go, and there'd be absolutely no point in doing it.
No, I may be being slow.
No, I may be being...
If you envisage a periodic tenancy, the tenant condition is met at the time that it is created by the presence of the husband in the home. There's then a need to exercise the jurisdiction of the matrimonial courts, and that periodic transfer is transferred to somebody else who meets the tenancy condition. I can't see why that isn't itself a secure tenancy.
But the point I'm trying to make is that the secure tenant is the husband, shall we say?
Yes.
Though actually these days it's usually the other way round. But the husband, so he fulfills the tenant condition. The whole premise of this is that husband and wife are separating,
Yes.
and the court orders the transfer of the tenancy to the wife. Obviously the husband is no longer there. And the court is doing that on the basis that the security continues, because there'd be no point in doing it if it was simply a periodic tenancy, because the landlord could bring it to an end by serving a notice to quit in the ordinary way, and there will be no security, and the court will be beating the air.
If the court has transferred the property, which is the periodic tenancy, to somebody who meets the tenant condition, then the result will be a secure tenancy. There may be arguments about whether it's a new tenancy or the same tenancy, but in any event, the tenant condition is met at that stage by the occupation of the wife.
It having probably not been met at the time.
That's the problem that your ladyship identified about 85.5,
Yeah.
which I think the only answer I've got is that 85.5 exists, but it does exist.
But then so does 91.3b.
Certainly.
Yeah.
Now, you could say, of course, the family courts have been getting it wrong all these years, because that's a perfectly possible scenario. I have a feeling it was a case called Thompson and Thompson, where the High Court decided that they could order, and of course there has been subsequent legislation on the basis of it, because it was extended to cohabitants in the Family Law Act 1996.
Well, I think, in fact, those are my submissions on issue 2. I mean, I repeat that the statutory scheme envisages that at all the various moments of transition there is in existence an actual secure tenancy, subject to the quirk about 85.5. Issue 3 is the human rights issue. The answer we've given to that in the printed case is Kopechki, and it's as simple as that, and in our submission that remains a perfectly good answer. In fact, I think we set out the adoption in domestic law of Kopechki by the House of Lords in a case called RJM.
So it doesn't guarantee a right to acquire property.
Exactly.
You look at,
So
find property there and it's protected.
Yes. And so that if we're right on issues 1 and 2, there is no property right of which either of the Mr. Austins is being deprived.
And Mr. Luger's argument that we should construe
It's circular.
is entirely circular.
It's absolutely entirely circular, yes.
Well, I think he admitted that.
Yes. Well, I think he said it sounded circular.
Certain circularity is what he says.
We say that is the end of it. I mean, obviously that doesn't demonstrate we are right on issues 1 and 2, but if we are right on issues 1 and 2, then Article 1, Protocol 1 can add nothing. As the court below recorded, there is no Article 14 argument. I'll keep quiet. There is no Article 14 argument. And
Are there any other problems? I mean, if you're wrong on point 2, I mean, what are the, I know, I understand how you put it, but I mean, Is there a problem if you're wrong? I mean, what's the problem if you're wrong?
Well, the problem I really do see is assuming that the version of 2 that the court is attracted by is the idea that the estate can make the application, then the problem is simply, well, I say simply, the problem will be to know on what principles the estate should act. It may well feel it is a good idea, whoever is the personal representative or whatever, to make the application, but they may not. It simply doesn't know. I understand Lord Walker's point that the commonplace will be that the person who is actually in occupation will succeed in an application to be made a personal representative, in which case there's an identity of interest between, there may not be. He in his capacity as personal representative will feel inclined to make the application because it benefits him personally. It's not obviously for the advantage of the estate. It's not an application that's being made on behalf of the estate at all.
Disadvantage of the estate.
Well, it might be. This is an outstanding amount of arrears.
Well, it's possible to imagine a fanciful example where the tolerated trespasser, even though he can't pay his rent, has made a will and appointed an executor and left his entire estate to the RSPCA, which says, why should we risk costs in going to the county court to try and preserve rights? Well, and the answer is, in that case, the brother who is there would have to say, all right, somehow or other I'll find the money to give you an indemnity for your costs. And if the personal representative still refused to go to court, then the brother would go to court and say, I'm not the personal representative, but I ask for the purposes of this application to be appointed to represent the estate. I mean, it's fanciful, but there is an answer in that sort of situation.
But I think that analysis is reinforcing our basic perspective, which is that there isn't any automatic identity of interest between the estate and the successor.
No, the successor is relying on the successor's own rights and not on anything inherited from the estate.
Well, exactly, but it may be on the example, the particular example I accept is fanciful, but on the example, he will be making an application which is contrary to the interests of the estate. There's no reason why it's for the benefit of the estate, qua estate, that the Lazarus order is made in order to guarantee succession. That's the fundamental problem. Obviously, in a commonplace situation, there will be that may not be a difficulty. But what Mr. Luber's argument envisages is that an application is made by the estate, qua estate, in order to benefit something that isn't the estate.
And as I say, there is a very familiar parallel of that under the Fatal Accidents Act.
But it's not to the detriment of the estate.
Well, it may be. If the estate of someone who has died in a fatal accident has been left entirely to charity, they could say, why on earth should we risk costs of losing a claim for of losing a claim which is not going to bring us any benefit at all? And in that case, it would then be necessary for someone else to be appointed to bring those proceedings. It's quite parallel, isn't it?
But in that situation, you wouldn't be bringing the proceed. I'm only working off your lordship's description of the scheme, for which I apologise. But in your lordship's example, if the estate is not, the personal representative is not willing to bring the action under the Fatal Accidents Act to benefit the dependents, then presumably you will solve that by appointing somebody to represent the dependents in respect of those causes of action.
In fact, in that case, the statute says that if the personal representatives won't act within 6 months, then the dependents can. So it does cover it. But it is nevertheless a comparable situation.
But in my submission, well, that's my point, though. I mean, what that drafting does is recognise that you're dealing with two different things. In the first place, you're dealing with the causes of action in the dependents, which may be conveniently dealt with by the personal representative acting. And secondly, you're dealing with the interests of the estate, which may or may not coincide. Now, Mr. Luber's construction is to create an interest by statutory construction. Interest can be transmitted to the estate, and then assume that the estate will make the application which does not benefit it at all, quiet estate. It's plainly, except to the extent that you assume that the tenant who's died and who had lived with his relative for a certain period of time would normally want, for family reasons, the succession to take place. But there's no other identity of interest. In our submission, that's the fundamental reason why this is a construction to defeat the characteristics of the scheme, as Lord Justice Longmore said. Well, I think those are my submissions. I don't think I need to add anything on issue 4, because my position was correctly summarised yesterday.
Thank you very much. Mr. Kelly.
Nothing to add, my lord, my lady.
Mr. Luber.
My lords, do I apprehend, in keeping with the timetable suggested yesterday, that the court would wish me to conclude my submissions in reply in the next 25 minutes?
Well, I make it, actually, I think we were going to go on until 1 o'clock anyway, so you've got 55 minutes, which might be enough.
But you won't need that, will you, Mr.
I won't need that at all, my lady, but I thought, my lord, given the indication that the court would wish to rise early for lunch.
No, we originally were. I should have made myself clear, but we no longer need to rise at 12:30, so we can run on until 1 o'clock.
Thank you very
And we
much.
can come back at 2 o'clock if you really want us to do that.
I shall certainly invite the court to do that, and I shall certainly seek to conclude my submissions before 1 o'clock. My lords and my lady, before I embark on my replies, my learned friends very clear and characteristically succinctly expressed submissions, may I make good the invitations that various members of the court put to me yesterday for additional materials to be supplied in the form of, as it were, some homework. And can I pass that forward at this juncture?
Our homework or yours?
No, my lord, my lady, we did the homework. These are
You're now giving it to us.
Yes.
Oh, no, my lord, my lady, it's enough of the judicial function that you will have the homework anyway. I'm not seeking to add to it, but to reduce it.
Thank you.
As my lords and my lady will see from the covering note of the materials just provided, what I've sought to do overnight is to deal with 3 specific questions which were raised yesterday. The first set of questions related to what we've been describing in section 85.5, and I'll say something more about those in a moment. The second was to provide the actual date for the 2008 Act, so we've done that by providing the long title. And I was asked to provide the Housing Act of 1988, that is the assured tenancy regime, and I've done that also. I hope those were the materials required. If there's any further we can supply, then of course we will at the invitation of the court. My lords, my lady, can I come back to such of that material as is relevant to my own friends' submissions in the course of replying to them, and invite the court to, as it were, put those materials aside for just 1 moment. My lords and my lady, may I deal with my learned friend's responses in the order in which he developed them? First, issue 1, and he articulated as his primary case, in answer to our issue 1 proposition, that this was all too late now. It would be wrong to revisit, even if it were otherwise appropriate to do so, the interpretation and construction of section 82.2, and indeed its place in the 1985 Act. My learned friend's opening gambit on that, in developing that general response, was that my client was seeking relief in what is effectively the dying days or last gasp of the statutory scheme. In my respectful submission, that is not right at all. The statutory scheme in relation to secure tenancies remains safely in place and on course. The effect of this court finding for us on issue 1 would be that the day after judgment, hundreds of thousands of people who live in council and housing association property would awake to find that they were no longer in limbo, but were once again tenants of their landlords. That's not a dying days syndrome, that is a restoration of the status quo ante, which is, with respect, precisely what issue 1 is designed to achieve. Some of the people who would wake up on the day after the court's judgment, if it found in favour of us on issue 1, would be only marginally better off. They would be people who could have, in any event, got their tenancies back on individual applications under Section 85. They could be people who are satisfied with the replacement tenancy regime in Part 2. The greatest beneficiaries will be the failed successors, of which the present appellant is a singularly good representative. So we say it may be becoming late, but it's certainly better than never, and it has significant gains. My learned friend then sought to meet the point that the decision of the House of Lords in Knowsley and White had done much the same thing in relation to assured tenants. And it is right, with respect, to remind the court that before the House of Lords handed down its speeches in December 2008, everybody in the assured tenancy sector who had been subject of a possession order since 1989 had thought that they were no longer tenants. There were tens, if not hundreds of thousands of people who were ex-assured tolerated trespassers immediately before this House handed down the House handed down its speeches in December 2008. The effect was very much the same. According to large numbers of occupiers, the rights that it had always believed that they had, and that that the House in Knowsley decided on a true construction of the statute, they had retained. My learned friend was strictly wrong with respect to him to suggest that the tolerated trespasser problem in the assured tenancy sector had only been alive for a few months, so not many people have been affected by it. The court will recall that the prospect of tolerated trespassers in the assured tenancy sector had been alive since the decision of the Court of Appeal in Artesian, which the House of Lords took the trouble to reverse expressly in Knowsley. And that decision had been given in 2000, or at least reported in 2000. It may have been decided earlier.
Which case was that? Sorry,
Artesian.
Artesian in 1999.
Yes, my lord.
Yes, I see. Overruled. Yes.
Yes, my lord. So the distinction my learned friend sought to draw, with great respect to him, as between the incident case and its effects, and Knowsley and White and its effects, is, if I may respectfully say so, rather more limited than he suggests. However,
Sorry, I don't know. I'm just looking at paragraph 74 of Lord Newberger. I'm not quite sure how you
I'm sorry, my lord.
make that good. I mean, he doesn't seem to make much of Artesian. He puts it in a brisk parenthesis at the end, but basically he's saying, as indeed Mr. Drabble, I thought, said, that nobody quite knew how matters stood in respect of assured tenancies until Knowsley, and he was contrasting that with all that he'd said in 73 on secure tenancies.
Yes, my lord, and it is right to record that there had been the understanding for longer in relation to secure tenancies that there was this positional problem of tolerated trespassers than was the case in relation to assured tenancies. That's certainly right, and the difference in period is more than 100%. The problem in relation to assured tenancies had only emerged with the decision in Artesian, and the position in relation to secure tenancies had been longer known in Thompson. The only point I was seeking to develop is that the impact, that is to say, on tens if not hundreds of thousands of people, is the same. The same benefit was gained by those who obtained the benefit of the reversal in Knowsley, as will be gained if we succeed on issue 1 in this case. Having made his submissions about it all being too late, the learned friend then deployed Schedule 11 of the Act and invited this court to decline even if otherwise tempted, to revisit the construction of Section 82.2 on the basis that this has all been addressed by Schedule 11. In my respectful submission, Schedule 11 is, if it can be, something to be avoided at all costs. Schedule 11 is only there in order to deal with the law being as it had been held to be in Thompson and Burroughs. So it's a fix for a problem that, in essence, we submit should not have arisen.
I mean, if Parliament had thought it was a good idea to avoid it at all costs, it would have gone through for the first option.
Well, my Lord, that is, my learned friend's right to say, a possibility. But as my Lord Hope put to my learned friend in the course of submissions, it is something Parliament singularly does not do, that is, retrospectively amend statutes. The safer course, in my respectful submission, would have been to find a case such as the instant case and run the proposition that the interpretation of the Act had been wrong. But there we are. My Lord Hope, in the course of exchanges with my learned friend, suggested that there might be a two-tenancy problem. I hope I don't misunderstand the point that my Lord was putting, that there might be somebody who, as it were, wakes up to find that they are both a former secure tenant and a replacement tenant. With respect, my Lord, that can't arise on the drafting of Schedule 11. It's behind tab 48 in volume 4, if we could just look at it very briefly.
I think I was really not looking at through Schedule 11I.
No.
So I was assuming one didn't need Schedule 11 at all. I was really disregarding it.
Yes.
But you're saying if you look at Schedule 11, it couldn't arise.
That's right, my Lord. Well, I thought the situation my Lord was putting to my learned friend was that if we were right on the construction of Section 82 and the court was prepared to reverse Thompson and say that Burroughs had wrongly approved it, then we wouldn't need Schedule 11 at all, and that's right. But there was the possibility, was there not, that we may nevertheless have replacement tenants by dint of Part 2. And the cut-off is made by paragraph 15b of Schedule 11, which defines an original tenancy, the first ingredient of the replacement tenancy regime, as being only applicable where the original tenancy ended before the commencement date pursuant to the order for possession, otherwise than on execution. If this court is with us on issue 1, then the previous tenancies never will have ended, and the first stage of the replacement tenancy regime will collapse. So my learned friend's absolutely right to submit, in my respectful submission, that Schedule 11 Part 2 simply becomes redundant if we are right on issue 1. There are huge plus points for taking that approach, in my respectful submission. I'll deal with my learned friend's negative points in just a moment, but one can see immediately that Schedule 11 and the concept of replacement tenancies simply bristles with further issues of substantive and procedural complexity, wholly inappropriate to this field. In the course simply of exchanges in this appeal, there has been identified an issue which apparently divides the London Borough of Southwark and those whom I represent, as to whether a person who is a replacement tenant can apply under the original Section 85 to restore their previous secure tenancy. That is a point of construction of some significance, and if it remains in dispute between the parties and Schedule 11 remains on foot, may need to be tested. But Schedule 11 itself simply bristles with other difficulties. On my learned friend's construction of Schedule 11, paragraph 21, the restoration of the tenancy during the termination period, or the running back of the tenancy, he appears to postulate a situation in which you get back some of your former contractual rights for some previous period, but not the rest.
Well, that's what Section 21(2) seems to say.
Yes, exactly so, my Lord. So we've already had a situation where housing officers are struggling to manage the idea that there are tolerated trespassers in their stock, and have been for the last 30 years. Now they're going to be told you will have people in your stock who are replacement tenants assuming you can work out what rights they get under paragraph 18 based on what rights they had under their previous tenancy, they may in addition have some rights as a result of paragraph 21. The recipe for chaos is enormous. The only upside of Schedule 11 is that identified by my learned friend, and that is that it preserves for landlords the existence of a termination period, the gap between the loss of the old tenancy and the commencement of the new replacement tenancy on the 20th of May 2009. But it is right in my respectful submission, before considering his submissions, that it's very important to protect the advantage that landlords have gained from the termination period, to recognise that the termination period is a windfall. If we are right on issue 1, as a matter of construction of section 82, there never should have been termination periods. My learned friend builds his case on prejudice on a windfall that social landlords obtain. And that windfall only arises, we know, from what were unintended consequences of the interpretation by the courts of the statutory provisions.
Well, that's what
the government says.
That's what the government says.
Yes, indeed it does, my lady. And my learned friend took the court in sequence through various parts of the guidance. I don't want to repeat his journey, but may I draw attention to the specific parts on which I would invite the court to focus. I'll only do that in relation to 2 of the documents, if I may. First, the summary of responses, which is at tab 53 behind volume 4. The summary of responses follows the style, firstly, of expressing an executive summary and then the government's conclusion, and then setting out a summary of the respondees' comments on each of the specific questions asked. My learned friend Mr. Drabble, in the course of his submissions, no doubt to save time, plunged straight into the specific responses. I would invite attention to the executive summary, in particular page 4. Now, the pagination is at the top centre of each page, and as I indicated earlier, has a rather unhelpful line just before each of the figures. Could I invite the court to go to page 4, where the heading executive summary appears over the paragraph 8. And this is the executive summary of the overall exercise. Paragraph 10 says, there was strong support for amending the legislation to restore the tenancies of all existing tolerated trespassers as being the simplest practical solution to the problem. The paragraph then continues, and my learned friend was right to draw attention to it, that some concerns were raised about the retrospective nature of the proposal, and nearly all respondents agreed that landlords should be protected from liability for actions taken in accordance with the law at the time. Protected from actions they had taken, certainly. No assent for the proposition that they should be exempted from liabilities. Can I go then to the government's position at paragraph 12 on the following page? Having summarised the responses, the government says this, paragraph 12, the government's concern is to protect the interests of both tenants and landlords and to ensure that a good balance is maintained between them. We recognise that the creation by the courts of tolerated trespassers causes serious problems for tenants and landlords alike. In recognition of the seriousness of this issue, and in light of a clear response to consultation, we've decided to resolve the tolerated trespasser issue, both for the future and in respect of existing tolerated trespassers. We'll use the opportunity provided by the bill to amend the legislation to prevent the creation of future tolerated trespassers and restore tenancy status to all existing tolerated trespassers. That was the government's response to the consultation exercise which had been undertaken. And that is why, when my learned friend came to show the court the non-statutory guidance subsequently issued, it is, in my respectful submission, a useful indicator of what the policy intention was. could I invite the court to a paragraph of the guidance, which is loose, which my learned friend put up yesterday, but is a paragraph to which he didn't take the call.
Before you do that,
Sorry,
just for completeness, 12 is part of the executive summary, so there'll be a detailed, specific comment, will there, that matches that later on in the document. Do we see it referred to later in the document, or does it not reappear in that form?
No, Lord, paragraph 12 is
Yes.
the government's position.
Yes.
Paragraph 13 indicates that this part of the report provides a summary of the responses to each of the questions raised.
I see. So
So it's a summary of the respondees' responses.
Yes, right.
12 is the government's overall conclusions.
Overall, right, I follow. Yeah, thank you.
But, my Lord, I'm grateful for that helpful indication, because it leads neatly, in my respectful submission, to the paragraph I wish to take the court in the guidance, which is paragraph 50 of the non-statutory guidance at page 18 of that guidance. And paragraph 50, page 18, is headed Terms and Conditions of the New Tenancy, and it says this: as already stated, the aim of the provisions, that's the provisions in Schedule 11, is to provide so far as possible that both landlord and tenant are in the same position as they would have been had the tenant not become a tolerated trespasser, and that neither is disadvantaged by the changes. That's the underlying premise of the approach to Schedule 11. It is understandable, however, that landlords lobbied, and successfully lobbied, to retain the benefit of the windfall that they had achieved from the existence of the termination period. And my Lord, Lord Brown asked my learned friend to identify what other benefits or issues there were, and he candidly said that the prime one is that there was no liability for repair in relation to the gap period. And that's what the landlords wanted to hang on to as the benefit they'd got from the windfall. Well, my lords, my lady, I invite this court not to be tempted off course by the fact that finding for us on issue 1 will deprive landlords of that windfall, not least for this reason: that would be an unbalanced result, because the occupier who has been in occupation without the benefit of the repairing obligations has been obliged to pay the full rent, or the equivalent by way of mean profits.
The counterpart would normally be the repairing obligation.
Exactly so, my lord. The counterpart of the payment of rent by the, quotes, tenant for these purposes, or the payment of mean profits, would ordinarily be that they get something back for it. So this is a windfall which is a double whammy for the former landlord. They are no longer the landlord, but they continue to receive, sometimes by dint of the court's order, the current rent and or mean profits. Now, it is that double whammy benefit for landlords arising from the construction in Thompson and Elmbridge that is the primary loss the social landlord sector would suffer if this House were to hold Schedule 11 redundant. The double whammy windfall may in any event have been an entirely Pyrrhic gain for social landlords, as Lord Newburger makes clear in Knowsley and White. In Knowsley, which is behind tab 18, Lord Newburger, in as it were in person, noted that this proposition arose that tolerated trespassers were paying effectively rent but getting no rights in relation to repair. It's dealt with in paragraph 83 on page 669. He says at the end of paragraph 83, penultimate sentence, in those circumstances, having described the proposition that the rights of an occupier in relation to repair have been lost, he says, in those circumstances, I consider there is a very strong case for saying that the landlord would be liable under the 1972 Act, that's the Defective Premises Act. In this connection, see Rogers and a case called Brickham Investments. But the point is not straightforward. And indeed it's not. And it's yet another piece of satellite litigation that will now arise if the tolerated trespasser scenario is retained. Because, as that paragraph suggests, there is a strong argument that if a landlord receives rent payable from a tolerated trespasser, then obligations in relation to repair are maintained in any event. There is already standing for hearing in the Court of Appeal a case which will examine the application of paragraph 83. Simply, as it were, suggest, in my respectful submission, that this problem of tolerated trespass, unless addressed on issue 1 in this appeal, will again continue to spawn this sort of satellite litigation.
So we read that last sentence with the previous one.
Yes, my Lord.
Because that's really making the point, isn't it?
Yes, my Lord. It really goes as a whole, that one can see the injustice on the one hand of saying there is no obligation, even though the landlord is, as it were, still continuing to receive the remuneration. In any event, the windfall has always been capable of being taken away on a successful application under Section 85 to revive the tenancy. But the simple fact is that so many in the sector are in ignorance of this tolerated trespasser status, and so few applications have been made, that this has not been an opportunity pursued very widely. There is, in our respectful submission, no good reason why a combination of landlord and tenant ignorance and misunderstanding, which has prevented tenants getting their tenancies back in that way, should now justify the continuance of this windfall gain for landlords, particularly where Parliament's starting point, on the basis of the government's own statutory guidance, is that it's trying to put everybody back to how they were. There is, in my respectful submission, a further reason why the court should not be deterred by the loss which my learned friend Mr. Drabble identifies, and that is because the loss he identifies is wholly transient and temporary. But the court will appreciate that Schedule 11 creates replacement tenancies from the 20th of May 2009. From that date, the tenants have had the benefit of repairing provisions, repairing protection. They can, if they succeed in their application under Schedule 11, add a period before the 20th of May 2009 and, as it were, enhance their compensation by taking back their rights. At present, they can do that for up to 6 years from the date they bring their claim. The most recent year, 2009-10, will be covered by the replacement tenancy, and they'll need the benefit of Schedule 11 for the prior 5 years. But with every day that passes, they have less need of the old tenancy, the gap period. And eventually, on what I calculate to be the 20th of May 2015, Schedule 11, paragraph 21, will cease to have any benefit at all. Because any claim brought on or after that date, which seeks the revival of the old tenancy, will be relying on a period prior to the limitation period. So Schedule 11, paragraph 21, which my learned friend is so keen to preserve, will in fact, in a short period of years, now 4 or 5, become entirely redundant.
Could you give me the paragraph number again that you referred to in relation to the date, 20th of May?
20th of May 2009 is the commencement date of Schedule 11,
yes.
my Lord, and that is to be found from the commencement order, which we have in the bundle at tab 49.
Yes. But it was a paragraph in the schedule you mentioned in passing, and I wasn't quite
Yes,
sure.
I'm sorry, my Lord, Schedule 11, paragraph 21 is the restorative provision. Lord Brown put to me yesterday, and put to my learned friend today, the opportunity to identify other classes of people who would be better stroke worse off, depending upon the approach that this House takes on issue 1. My respectful submission, my learned friend was right to identify that the core beneficiary of this change is the landlord who hasn't repaired, and the core beneficiary of success on the appeal is the hundreds of people who are failed successors.
I know we focus almost entirely on repairs. I mean, I don't know. I mean, if you go down your road on issue 1, I mean, what happens to people who've been dispossessed? I mean, can they bring a claim?
Well, my Lord says dispossessed. If they were dispossessed on execution of the possession order, their tenancy will have terminated. That is precisely the construction of section 82.2 for which I contend. If they have gone out voluntarily, then they will have surrendered. If they had entered into a new tenancy agreement, there will have been a novation. It is exceptionally difficult, and it's a difficulty that both I and my learned friend Mr. Drabble have found, in identifying for the benefit of the court and the application of the issue 1 point, whether there are any other losers or gainers. And that's why we focused from the landlord side on the possible liability for disrepair, and on the occupier side on the loss of gain for those who are failed successors. My lords and my lady were encouraged by my learned friend Mr. Drabble to hold back. I'm sorry,
what? Just, a supplementary.
Sorry.
What about successor tenants? They wouldn't, because there wouldn't be successor tenants on the borough's scenario.
No, that's this case, my lord, and the others like it.
Yeah.
If we succeed on issue 1, then the late Mr. Alan Austin never lost his tenancy, and when he died in 2005, Mr. Barry Austin, the present.
I know, that's fine, because he's still there. But what about those who have left, because they were regarded as not having rights to succeed as secure tenants?
Yes, my lord, they will have left, the property will have been relet, and there will be no question of them being able to assert that they are secure tenants because they've ceased to occupy the property.
Or claim at all?
Or claim
no
at
other
all?
Sort of claim?
Well, if I may respectfully say, I'm happy to meet the extrapolation that arises from my Lord's question so far as I'm able. It may be possible to think of a situation in which someone can say, I relied on advice from you, which was wrong, and acting on that, I left. And that would be no different from the position of any lawyer who who gave advice based on what they understood to be the present position of the law, which was later clarified. That's the only situation in which there could, as it were, be comeback as a result of the individual having left. If they leave of their own motion, then no such comeback arises. I wish to reassure my lord, if I can, that I didn't fail to do that piece of homework, and like Mr. Drabble, I have been trying to find other examples, and I haven't been able. My lords and my lady kindly gave attention to two decisions of the House of Lords yesterday, the barrister immunity case and the rights of way case, which we have both had an opportunity to consider overnight. We're grateful for those indications. In terms of the barrister immunity case, I think my Lord Hope, when mentioning Hall and Simmons to my learned friend, was met by the rejoinder from Mr. Drabble that may have been a case in which there had been no subsequent legislation after the House had fixed the policy of immunity back in the 1960s. In fact, an examination of the case shows that there was some statutory intervention on the question of immunity. My lords and my lady will recall that in the Legal Services Act 1990, Parliament expressly extended to solicitor advocates what had been perceived to be the immunity of barrister advocates. And in Lord Staines's speech at page 683 and Lord Hoffman's speech at page 704, both pay attention to the question of whether the House should hold back because there had been some parliamentary intervention in the field. And for the reasons they give, both explain that they should not.
And those pages are in, I think my recollection is right, 2002 appeal cases. 2002 one appeal cases.
2002 one appeal case is 615, my lord, and that was the page numbers I was giving was based on that. Page 683, Lord Steyn, page 704, 705, Lord Hoffman. But it is, in fact, the rights of way case to which my Lady Hale drew attention yesterday that perhaps provides the safest guide here, because that was a situation in which statute had proceeded on the premise that the law had been correctly stated by the superior courts, albeit the Court of Appeal and not this court. The argument of learned counsel for the landowners in that case, in the passages to which my Lord Walker drew attention in exchanges with my learned friend, are, if I may respectfully say so, entirely apt in this case. Indeed, you only have to change the name of the Court of Appeal decision from the name, I think, Hanning in that case, to the name Thompson in this case, to be almost on all fours. And it was that proposition which the House rejected, as my Lord Walker drew attention to, my learned friend, in the course of the speeches, in particular of Lords Hope and Scott. Of course, that was a different case, in that the proposition of law had been stated by the Court of Appeal and not previously approved in any considered judgment by the House of Lords. And I do remind the Court with respect that this instant case is not that far different. Thompson and Elmbridge was never re-argued in the House of Lords. It was treated by the parties in Burroughs and Brent as having been correctly decided, and I don't seek to develop that point further. My Lords and my Lady, in an attempt to make good my timetable, may I move swiftly to the secondary way in which my learned friend sought to answer our case on issue 1, and that was the issue of construction in relation to section 82.2. Can I invite the Court for this purposes, just once again, please, to turn up section 82 in volume 4, behind tab 42. My learned friend suggested that we had not identified any alternative construct of section 82.2 from that adopted by Lord Justice Russell in Thompson and Elmbridge. With respect to him, my learned friend was right to record that what we had done is rely entirely upon the construction identified by Lord Newburger as being the subject of a powerful case in Knowsley and White, and it is that which we seek to pursue. Could I invite the attention of the House to what must have been the situation and function of section 82 before we come to the exact words used? Parliamentary draftsmen in 1980, when Parliament was giving security of tenure to tenants of council houses, needed to devise, obviously, a textual means of doing that. He was struggling with a new methodology because Parliament had decided not to adopt the same route as had been adopted for the Rent Acts. That is to say, to allow the landlord to determine the contractual relation and then spring up a personal right to retain occupation. The Housing Act of 1980, becoming the 1985 Act, operated differently. Its device was to allow the continuance of the contractual tenancy and prevent it from termination under what became Section 82 of the Act. The structure of security of tenure, therefore, under the 1985 Act, is to clothe an existing contractual tenancy with a statutory covering of protection, completely, as it were, different in methodology, although in outcome the same, to the previous Rent Acts. The whole bundle, contract plus statutory rights, was to fall, and only fall on a landlord's application, by the obtaining of an order for possession. And that is what Section 82 and its predecessor in the 1980 Act sought to address. As Mr. Drabble put it this morning, the question that these provisions seek to answer is, when does the landlord and tenant relationship end in a secure tenancy case? That's what Parliamentary Counsel was tasked with embarking upon. And he had to do that, he had to ask and answer that question because Parliament had not left it free, as it had in the Rent Acts, to the parties themselves to determine the relation on the basis they wished. As my Lady Hale indicated, nothing in Section 82 prevents the parties otherwise terminating the relation, for example, by the tenant giving notice to quit or by surrendering. Hence we have the wording of Section 82. In my respectful submission, the words which are actually used there, and I don't shy from them, I shall address them further in just one moment, were settled in this context. First, Parliamentary Counsel knew that this provision was going to apply to about 2 million occupiers of social housing at least at that date. He knew, therefore, that many orders for possession would be sought and obtained, tens of thousands at least, hundreds of thousands possibly. He also knew, based on long experience from the Rent Act situation, that very many of the orders that would be obtained would be suspended orders. That is the point Lord Neuberger picks up in Knowsley and White. And he knew that even if the form of possession order obtained was an outright possession order, the landlord would not instantly be able to recover physical possession, because the statutory and procedural scheme always included a warrant stage if the landlord wished to recover possession. A warrant for possession was needed after the order. He must, in my respectful submission, therefore have known that a considerable number of occupiers would remain in occupation post the making of the order itself. If one had been standing by the shoulder of such draftsman and asked him in 1980, "Are you designing a scheme under which those against a possession order is obtained but remain in occupation will be in a legal limbo for years or indefinitely under the shadow of the order?" he would have said, "Of course not." And if asked to prove that, he would have said, first, "Well, that makes a nonsense of the policy of the very legislation I'm drafting, which is to provide at least equivalent protection for the public sector tenant as the private sector tenant enjoys." Secondly, he would say, "That can't stand with what I've already written in section 121. But what he would say, positively, is all I am doing is I am making it clear that when possession is to be given up in pursuance of the order, when that date eventually arrives, both the statute and the contractual tenancy end. And that dovetails with what I've written in section 85 about the extended discretion ceasing to be available at execution. The person standing over his shoulder may have said, "Well, no, surely in section 82.2 you mean the date that the judge puts in the possession order." At which the draftsman would have said, "Well, if I'd have meant that, I would have written it, not least given that I wrote it 4 lines further on in section 82, subsection 3, which provides, where a secure tenancy is a tenancy for a term certain, but with a provision for re-entry or forfeiture, the court shall not order possession of the dwelling house in pursuance of that provision. But in a case where the court would have made such an order, it shall instead make an order terminating the tenancy on a date specified in the order." He would have said, in response to the questions put to him over his shoulder, that if I'd meant the date specified in the order, as opposed to the date on which possession is to be given up in pursuance of the order, that's what I would have written. So, in my respectful submission, my learned friend is wrong both on his first answer to our issue 1 and on the second. The court should take the opportunity, in my respectful submission, to correct the construction of section 82.2. May I then, for my last 5 or so minutes, deal with my learned friend's submissions on issue 2, that is to say, assume we are wrong and Alan Austin's tenancy was lost. The respondent, Mr. Drabble, has to establish that it is implicit in the legislation that the extended discretion in section 85 ceases to be available on the death of a former secure tenant. That's what he has to show. It's certainly not explicit. If he were explicit, he'd have pointed to the provision. He has to establish that it's implicit that section 85 ceases to be available when the former secure tenant dies. He can't say it ceases to be available when a secure tenant dies, because the legislation envisages the secure tenant's death not ending the tenancy. Even if the secure tenancy has become a contractual tenancy, as we've seen from section 90, it can survive and vest in the usual way. He's got to say it goes on the death of a former secure tenant. Although a former secure tenant only exists at all because of section 85. It's because of section 85 we have tolerated trespassers. The very beneficiaries or the people created by section 85 are the people, he says, on their death it all goes. he's got to overcome the presumption that the statutory protection survives death. See reckless. The position adopted by my learned friend is, with respect to him, an extreme position with extreme consequences. Firstly, he appears to accept that the death of the former secure tenant prevents the former secure landlord making the application under Section 85. You can't say that by reference to anything in the statute. Secondly, he's got to say that the court can't make a Section 85 order of its own motion. That's extraordinary. That's not shut out by anything in Section 85. And if I may say so, picking up the theme offered by Lord Walker, it meets with the practical reality that the judges in the county courts in this class of case are often having to identify that when faced with a housing officer on one side and a former secure tenant on the other, exactly what should happen. Thirdly, it seems extraordinary, given the existence of Section 85(5), which one might think would be particularly useful where there had been a death of the former secure tenant. Even more extraordinary, given that the parliamentary draftsman will have known that in order to turn out the family left behind, the landlord will always need a warrant for possession. My learned friend is therefore, in the course of his submissions, candidly driven to the proposition that simply death of a former secure tenant ends the availability of Section 85, even if, as my Lord Brown put to him, he's sitting in court waiting for the judge to pronounce judgment on his application. It's at that point, I think, that it may be convenient for me to deal very briefly with Section 85(5), why we've got it and what it does. And I hope I've tried to assist the court in that respect by the additional material passed up this morning. I was asked yesterday when Pen and Dun was decided. I've given the date for that. It is in fact reported. I've not copied the case. I apologise if that is unhelpful. I was asked when Section 85(5) got into the statute, and what I've reproduced is firstly Section 75 of the 1980 Act, which is the section that put subsection 5 equivalent into the Rent Act. I've then at page 2 of the photocopying, using the pagination at the top right-hand side, it included Mr. Arden's annotation of that change, which refers to Pen and Dun and explains why it was done. And I've also identified in this cover sheet that the provisions of Section 85(5) have in effect always been there for both secure and assured tenants, as it were, from the inception of the regime. I was in difficulty when my Lady Hale asked me about it yesterday in identifying whether Section 85(5) had been there since secure tenancies had started, and I now know the answer to that. They are, because they were expressly included in Section 87 of the Housing Act 1980, which was the first enactment of the extended discretion now found in Section 85. In the course of exchanges this morning, however, my lady pressed my learned friend to assist on the question of the interface between matrimonial rights and the statutory regime for secure tenancies. First, my lady put it to my learned friend, how does the tenant fulfil the tenant condition if he goes out but his wife remains? The answer to that, my lady, I'm able to give not from any materials before the court, I'm afraid, but the answer is that the Matrimonial Homes Act, in the Matrimonial Homes Act 1983, which was the version in force when the 1985 Act applied, expressly provided that matrimonial home rights designated the spouse as the tenant for the purposes of the tenant condition in both the Rent Act, the Housing Act 1988 and the Housing Act 1985.
In other words, put the spouse in the shoes of the...
Exactly so, my lady. That's right. And then, if various orders were made under the relevant matrimonial legislation, the same for former spouses, eventually cohabitees, and as my lady now appreciates, civil partners, and so on and so forth. So that's how it worked. That's what made the supplementary decision in Thompson and Elmbridge about Section 85(5) so extraordinary, because Parliament had plainly put 85(5) there to deal with exactly that position, where one spouse goes and the other remains. I'm afraid I must deal with another point that came up this morning, raised by my Lord Hope on section 91, because I need, with respect to my learned friend Mr. Drabble, to correct his answer in relation to that. Section 91, 3C, as the court will recall, we went to as an example of a situation in which a secure tenant can assign their secure tenancy.
Yes.
And I hope I didn't give the impression to my lord that this was a situation in which an assignment could take place after death. The purpose of section 91.3c is to enable the secure tenant to assign while alive to somebody who would succeed them or could succeed them on death.
Yes.
My learned friend suggested in the course of his reply to my lord's question on section 91 that such an assignment could not take place unless the tenancy were secure. I'm sure he did that entirely inadvertently, because the section which says the reverse is only reproduced in the appendix and not in the version which is behind tab 42. And that is the provision for my lord's note. In section 95 of the Act, which is on page 106 of the appendix.
Oh, yes, I see. Yes.
The function of section 95 is to ensure that if, as it were, while you're insecure, you've temporarily gone out of occupation, for example, you assign, then nevertheless the restrictions on assignment and the exceptions to them apply with the modifications shown there.
And that was in the Act from the start, one understands from the derivation provision.
Yes, my lord. Yes. And I think entirely inadvertently, I'm sure, Mr. Drabble said tenancies can only be assigned while they're secure, and that's not the case under the statutory regime. Finally, in terms of questions on this issue this morning, my lady asked about the Matrimonial Causes Act 1973 and the assignment of the tenancies. My lady was quite right. The case that decided that an assignment could be ordered as a property adjustment order was Thompson and Thompson, endorsed by the Court of Appeal subsequently in a case called Hale and Hale, which...
there are a lot of us about.
Well, indeed, lady, and that case singularly important for those of us who work in housing, because it showed that a secure tenancy was property for the purposes of sections 23 and 24 of the Matrimonial Causes Act 1973. It produces a situation for a spouse where she or he has two ways of getting their hands on a secure tenancy. One is by vesting, which would be achieved under what was the Matrimonial Homes Act, now the Family Law Act, or alternatively by assignment, which is what you get if you proceed under the 1973 Act. My lords and my lady, I have about 4 more minutes. If I may, I'll continue just shortly. I was addressing the court on issue 2 and suggesting that my learned friend had to show that the statutory scheme envisaged a loss, a shut-off of the availability of Section 85 on death. He says that's inherent from the scheme. With respect to him, my answers to that proposition are as follows. Firstly, that this is a scheme which contemplates and expressly deals with death. Sections 87 to 89, Section 90, and the right to buy provisions all deal with death. If death had therefore been a cut-off for Section 85, it's astonishing that the Act doesn't say so. Secondly, Section 85 requires the making of no application. It doesn't say you can't apply once you're dead, because you don't need to apply at all. Section 85 is simply a descriptor of the discretions available. Thirdly, as I've already indicated, we have Section 85.5 expressly building in a provision which is likely to be very useful where a former secure tenant has died. Fourthly, Section 85 includes an express limiter, that it's not available once the order has been executed. On reflection in the course of argument, it has become clear the way that my lady and my Lord Walker in particular have been putting questions to myself and my learned friend, that a more appropriate way perhaps of advancing and understanding the appellant's case is to simply put it in this way, that the respondent has not shown why the statutory discretion cannot be invoked after the former tenant has died. The respondent has not shown why the statutory discretion cannot be invoked after the former tenant has died. That strips out the, as my Lord Walker has described, inappropriate in context issues about estates, personal representatives, and so on and so forth. It puts it very simply, Section 85 is available unless the statute, expressly or impliedly, indicates that it's not. And there is no such express or implied indication. And finally, can I deal with 2 points raised by my Lord Brown in relation to this point? First of all, Lord Brown put to me yesterday that it was not unknown for some causes of action not to pass on death. And my Lord was absolutely right and gave me the example of defamation cases. With respect, I would remind my Lord that that is because defamation is expressly accepted from passing as a cause of action by Section 1 of the 1934 Act, which is in the appendix at page 81. All other causes of action will pass. The second point is a point my Lord Brown put to my learned friend this morning, and that is as to advantages and disbenefits if we're right on issue 2. And if I may respectfully say so, my learned friend was absolutely candid in this regard. It's very difficult to identify any disbenefits, that is for landlords or tenants. The advantages are obvious, and they include, in the instant case, the person that statute intended should succeed a secure tenant, namely his brother, may be enabled to do so.
Well, thank you very much indeed. We're extremely grateful to Council for their assistance, both orally and in writing, and also for sitting at 10 o'clock today so that we're able to finish at such a convenient time. We will take time to consider our decision, which will be issued in due course.